Union Repeal 107 of 8.
Dismissed. Okay.
Item number 58, WPC 276 of 2014.
Allowed and recalculate.
Item number 59, 3605 of 15.
Here we have decision is taken, some fine tune is required. We are allowing interfering. But what next? You notionally fix his no back wages, notionally fix his salary on the date of his actual retirements, and if entitled for any benefit, calculate on that basis. That's
Item number 60.
Record is
record. I'll give the record just
07.
by evening or tomorrow. Here this case, Mr. This another case is there, na?
Yes.
Here in this case, we have said that you can transfer the money to his account of choice. However, subject to any judicial order that has been passed in by the magistrate.
Item 61, W283 of 2017.
Remanded back.
Item number 62 and 63, W271 of 22.
Gogoi, we have held that you can not have a power not to renew for revenue consideration. That we have upheld. However, the exercise of power, more particularly under sub-rule 6, because he may place the claim that there was investment he could not run, that he is having a vested right for consideration. So we have remanded it back, setting aside.
May I please, Your Lordship?
Yes.
On a time praying on behalf of Mr. A. Alam, he informed me over telephone me that he is not physically well today. And that I'm praying for item 18. And he has taken the consent from petitioner. He is the respondent.
Items
18 on 8. Next week, will it be possible? Yeah, admission. Part 14 possible.
item 8 next week.
1
18.
18. I'm blessed.
You are for respondent. Okay.
Yes. That's why I recommend item 8, Lordship. Motion item. Lordship. Mr. Arali is out of station, Lordship. Matter may be
Adjourn.
next week, Lordship.
Next week.
Your Lordship, I beg to mention an IA, Your Lordship, arising out of a criminal appeal, Your Lordship, for suspension of sentence, Your Lordship. It was last listed on 28 February 24. It was supposed to be listed after 4 weeks, Your Lordship. So, Lordship, kindly on 25th, Your Lordship. He is in jail, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention for listing of a bail application, Lordship. Bail application.
439, 438.
439, Lordship. Day after tomorrow, Lordship.
One, motion VA.
May I please, Lordship.
Yes.
My Lord, as on today, 27 days is in custody, Lordship.
CD. When?
8th of May.
8 of.
Obliged.
Item 2.
Written an application, Lordship. Delegation is under section 366, and the accused is behind the bar for.
Mr. Das,
My lord.
he have made a specific statement that her 164 at paragraph 6.
Paragraph 6. Yes.
How can we, when can we have the case diary? If there is a, what is statement we do not know. If there is a relation, she is a major, then why should we keep a person inside?
My lord, yes.
It's a Udal Bakra or something like that.
Dispute, yes.
Dispute.
On Friday.
Friday?
As a commentary, hope.
Just that much, because
Hello?
that has been recorded
yes, yes.
already.
That dispute, the girl has been recovered.
Recovered.
No
So
problem.
therefore, otherwise we are inclined to give today itself.
My lord.
But only difficult, we do not know nowadays
Oh, yes.
what was his intention. Trafficking may be there, we do not know.
These things are going on.
So that's why.
P,
My lord, may I please your honor, for the convenience of the court, my lord,
Hmm.
may I pray your lordship to take up the item 4
Hmm.
first. 4.
We'll have the case there.
Definitely, my lord.
That's why give a date. It's Sondrapur.
Is out of,
Sonapur.
the dispute is out of land dispute, purely.
Maybe there is a land dispute, but there is marpit. And some persons were seriously injured as per allegation.
My
So I suppose civil dispute will not permit people to involve in this.
One
When?
prayer, my lord.
On
Just one
2nd
prayer.
of May.
My lord, police forwarding report says that all are fit persons. That is why occurrence took place on 29/3/2024. On the same day, they are forwarded to the police station, this accused person, and the cross case is there. Both the cases, all the accused persons are.
Along with which case there is?
My lord, Sonapur police station.
No, this case we'll write it down. According to you, which one is the case? Other case.
Other case is.
Cross case, your cross case.
It's my lord.
Yes.
Yes, what is the case number?
Yes, my lord, I am coming to that. It is Sonapur police station case number 55/50, 55/2024.
Where do we get that? Which page?
At page 2, my lord. This is relating to Sonapur police station case number 55/24.
Page 2.
Another case that is related to 54/24. That is item 3.
You are seeking bail in Sonapur PS case number
55.
55.
It is not 54.
54.
54.
That's why.
Item number 3 to be man.
Item number 3.
Sonapur case number be man.
Item number 2 is 54. Huh? 3 is 54.
My lord, absolutely right.
Is not it?
My lord. That is
And what about item 4?
item 4, a hot box,
Sonapur PS 55.
55.
We are calling case there in both the cases.
My lord, fixing a short date, my lord,
PP.
26, my lord.
That order we have already passed in both the cases.
My lord, on 26th April, my lord.
26.
Along with my lord, medical report, my lord.
Election is there. 26.
20.
25, my lord, along with medical report, my lord. Because 326 there, and so far my knowledge is concerned,
Second is, I think your date is
29. Oh, yes. The second will be better.
29th.
I'll leave it to the court.
No, we can call it.
But if
People
we-
are busy with the festival of democracy. So therefore, we cannot force them, and at the same time, if CD is not coming serious allegations, so we'll have to
My lord, along with medical report, my lord.
2019 along with medical.
Obliging, my lord.
Lordship.
Yes.
Lordship, 439 application.
Mm.
Arrested on 28/1/2024.
Mm.
Only on the ground of length of detention, my lord, I am praying. my lord. As on date, it is 85 or 86 days, my lord.
Unsound mind.
My lord, 90 days is, my lord.
Your right will come after 90 days, not before that.
But my lord, in the FIR, if my
We do
lord,
not know.
The charge sheet has been submitted or not.
Charge sheet has been submitted or not.
I have inquired regarding that aspect.
We'll have it on Friday. When? Today is 86 days.
86
We'll
days.
have it day after tomorrow. Mr. Das,
My lord.
have the instruction.
Can it be on 25th, my lord?
25th.
25th. Oblige me.
CD.
Item number?
But here I am challenging in fact, two orders passed by the learned court of judicial magistrate first class as well as the learned session court, my lord. The case is, my lord, the respondents herein filed a domestic violence case.
Where is the bar? Your whole ground is there is a bar under the act. Where is the bar?
There is no bar, but
That if no bar, your petition is liable to be dismissed right away and rightly dismissed. That is the only ground.
so far as the question regarding jurisdiction is concerned, my lord, there was no finding given by the learned court of judicial magistrate, my lord, as well as the session court. And the only plea I am raising before this honorable court to, my lord, that the court may not have the jurisdiction, it may not be correct, but so far as finding it,
Is your mother?
yes, my lord.
How much cost will you deposit? Over and above paying the complying with the order to issue a notice. No stay for a notice, the litigation fees for the mother, and assurance of continuance of payments of maintenance or withdrawal.
If I may take instruction, my lord.
Mr. Biswas, learned counsel for the petitioner, press for an adjournment to obtain instruction whether the petitioner shall would like to pursue this present petition. List it on Friday.
But in the meantime, we may be allowed to file an additional affidavit to bring on record some documents, my lord, which are necessary for the disposal of.
Do whatever you like. Our permission is not necessary.
Much of it.
Friday.
Concurrent findings of guilt, my lord, under the NI Act.
Mm.
I was sentenced to undergo a simple imprisonment of 6 months and to pay compensation of 26 lakhs, my lord.
Mm.
And the primary consideration here, my lord, in this case,
Mm.
complainant alleges that he sold the JCB for 16 lakhs of rupees.
Mm.
2 lakhs and 10,000 were paid upfront.
What is that glaring illegality?
Clearing illegality, my lord,
Glaring.
my lord, the court has not considered the fact that for discharge of, there has to be a subsisting debt or liability, my lord,
Mm.
in order to attract the penalty under section 138. Here, the complainant himself says that I bought the consideration was 20 lakhs.
Mm.
Sorry, my lord, 16 lakhs,
Mm.
out of which 2,10,000 was paid upfront.
Mm.
So, my lord, the outstanding liability would be 13 lakhs and 90,000.
Mm.
Check value is, my lord, 20 lakhs. So, the check value does not tally with the legally enforceable debt or liability. This aspect, my lord, has not been considered by either of the learned trial court as well as the appellate court, my lord. There are some discrepancies and anomalies in our defense, my lord. But when the complainant himself, the case of the complainant himself, my lord, suffers from this defect, my lord. So, my lord, punishment under 138, my lord, was not justified. And this aspect was neither considered by the trial court or the appellate.
Okay, show us.
My lord. On page 18, my lord. 16, my lord, is a trial court judgment, my lord.
Mm.
On page 18, my lord. Second paragraph, the factual part, my lord.
Page
18, my lord.
18.
18, my lord. May I read, my lord? The matter specifically says that complainant desired to sell the vehicle to the accused and the sale consideration was fixed at 16 lakhs. Both sides entered into an agreement by the instrument number such and such on this in this regard. And on that very day, accused paid 2,10,000 to the complainant. No matter page 19 gives the two check amounts, my lord. Two check numbers 565347 and 565348, amounting to rupees 10 lakhs each.
Where is the determination?
My lord. Starts from page 22, my lord.
What was the amount? Check amount.
Check amount 20 lakhs, my lord. Two checks, my lord. 10 lakhs each.
Where is the finding of the legal due?
Page 15, my lord. Sorry, miss page 25, para 15, my lord.
Where is your suggestion that this was your defense?
My lord.
Your
My
defense
lord, I
was
have taken this plea, this regarding this, whether
Ah.
this does not cover the check amount. My lord will find that at page 28, para 20.
case.
Page 28, para 20.
No, in evidence.
My lord, we have not annexed the copy of the evidence, my lord.
We need the evidence.
Sir, LCR will be required, my lord.
Huh?
LCR will be
No,
required.
we'll not call the answer. You give us the certificate.
My lord.
You are in a revisional court date to after two concurrent findings. You
No, no,
don't
I-
have any right for issuance of a notice. Give us the evidence and show that you have suggested.
My lord, I have it.
Cross-examination,
There are some underlinings, my lord, that is why we did not.
no issue.
Regarding this, my lord.
He has clarified.
My lord, no, my lord, he has said
Ah.
that this amount has come with interest.
Ah.
In his complaint, he does not mention anything about interest.
He says it's legal due. Is
No, my
it
lord.
necessary always to mention that it
No,
is
no.
legal? This is the actual due. This is the interest. Are you in a civil suit?
No, my lord, but then if he says that, my lord, that interest, this amount comes to interest. He has not mentioned the rate of interest. And my lord will notice one thing.
No, we are not, they're not taking a decision what should be rate of interest, what not. It's a negotiable.
My lord-
Whether he has discharged his burden, initial.
My lord, his burden, as per Rangappa Mohan, my lord, the burden, it's rebuttable burden. It can be
Rebuttable burden.
it can be rebutted either by the accused by deducing his own evidence or by relying on the evidence of the complainant himself. In his chief, he does not mention about any interest. He specifically says that 16 lakhs was due.
He says that I have this much of due.
Due.
And he clarifies that actual amount is this, interest is this, therefore total check is given this.
no,
What
it-
more is required
no,
in negotiable instrument act?
Let me humbly submit, my lord. The check, the liability amount as per his own admission is 13 lakhs and 90,000. The agreement is dated 16/10/2020.
Cannot determine all this factual aspect when you have not taken all these things.
So we have taken a specific plea
Hmm.
that this was not the due amount. And within 5 months, my lord, whether a rate of interest would have been imposed from which would take the liability from 13 lakhs 90,000
That
to
is
20
not a
lakhs. my lord.
lookout of a case under 138.
My lord, but if he has not pleaded this in his complaint or in his evidence, my lord, then all of a sudden, when I have confronted him in his cross-examination, that how come your amount has come to 20
This is
lakhs?
you who have got it explained.
Yes.
This is not your suggestion either. There is no suggestion to that effect. You have not prepared the defense case.
But there are anomalies in our defense, my lord. We admit that,
No,
my lord. But
That cannot
but
be.
this presumption stands rebutted if there are anomalies in the case of the complainant. That is, my lord, settled law. That if there are anomalies in the evidence of the
Argue it
complainant,
tomorrow. We'll decide tomorrow.
my lord, at least notice may be issued
No.
at this stage, my lord. Because my submission would remain the same, my lord, on this fact that 13 lakhs 90,000 was the liability
No,
amount.
today is a motion. We cannot dictate the judgment right now. Or after the list is over.
I leave it to your lordship, honorable lordship.
Tomorrow.
Yes, my lord. This is a case where I am the registered owner of a vehicle, my lord. I was granted Zimmer of the vehicle. Bank
Yes,
guarantee was.
yes, sir. I had an order.
My lord, I have the order, my lord. Your lordship had passed.
Dispose of.
Be closed, my lord.
Allowed. Yes.
Nine.
My lord, with all respect, my lord, family dispute, here what has happened, my lord, restitution of conjugal rights on application is pending. Then, my lord,
Heard
FC.
Mr. B. Mahajan, learned counsel for the petitioner. By way of the present application under section 482 of the Code of Criminal Procedure 1973, a proceeding being ASCW number 129/2023 pending before the Assam State Commission for Women, Beltola, Moidamgao is challenged. It is the case of the petitioner that litigation as regards maintenance and
Restitution of conjugal.
restitution of conjugal rights between the parties are pending before appropriate forum. And in view of such pendency before an appropriate forum, the Assam State Commission for Women, what you call State Commission for Women, shall have no jurisdiction to entertain such an application. Issue notice returnable after 4 weeks. Considering the issue involved, this court is also prima facie view that when litigation as regards maintenance, payment of maintenance under section 125 CRPC, as well as for restitution of conjugal right between the parties are pending, the state commission shall should not exercise its jurisdiction.
Mile,
Full stop.
mile.
Accordingly, the proceeding being so and so, pending before so and so shall remain step.
Highly
suspended. Steps within 5 days, so and so accepts notice on behalf of the public.
Malad, if possible, Malad, I do not know, Malad, student, if possible, Malad, that 10F has not been violated, Malad, of the act, Malad. And then he has.
They are recommended, it's a recommendatory.
Malad. Highly obliged.
What লিখে দিব? Further, this court is also of the prima facie view that
Oh, I'm sorry.
prima facie view that
Devoid of jurisdiction.
prima facie view that in view of the parties availing and adjudicating their rights before appropriate forum, there may not be any occasion to take suo motu cognizance
Mile.
of such proceeding by the commission.
Highly obliged. Obliged.
Yes.
My lord, subsequently, my lord, the accused number 1, my lord, arrested and subsequently released on bail. And the charge sheet was filed, my lord. I was shown as absconder and the summon is issued, my lord. Your lordship was rejected earlier, saying that they are their stage of investigation that cannot be granted. Our plea, my lord, this case is a case of suicide, my lord. And the FIR was filed.
Your bail was rejected by this court, anticipatory bail. At this stage, no question of anticipatory bail, grant.
My lord, subsequently, my lord, the accused number 1 have been arrested. He have been released on bail. He has been released on bail. And this is, my lord, absolutely the case of suicide, my lord. How can I can interfere, my lord, to my sister's family, my lord? He is my sister's.
Who was arrested? Petitioner number 1 was arrested. Where is
No,
the
no, my lord. Petition number 1 is not arrested.
accused
Accused
number
number 1 is arrested and released on bail, my lord. And I am my lord, the victim is my sister's husband. And in fact, my lord, there is a dispute, my lord. There is a domestic dispute, husband and wife. This is the.
You want to, after bail was rejected, investigation completed, charge sheet file. Now you want to ask to grant an anticipatory bail on the ground that there is no case is made out. Is it permissible?
This is right here.
Huh?
This is.
Is
right
it
here.
permissible? Tell us first.
No, my lord.
If no, then we are dismissing this.
My lord, kindly see, my lord. My submission is done, my lord. The accused number 1 have been arrested. I have been absconding, madam. Now, if your lordship granted bail, my lord, I will take part in the trial, my lord. I will participate in the trial.
Only he can appear in the court below, lordship, court will dispose of. As per
My lord, in the
that
similar case,
matter.
my lord, in the similar case, I may be referred one order, my lord. In the similar case, ordering case granted bail, I may be allowed to refer this order, my lord.
Then there is no, there will be no issue of rejecting any bail. We'll reject, you will come that I have been declared an absconder and we'll grant you bail. What is the meaning of
Any condition may be imposed. I will participate in the trial, my lord. Any condition may be imposed. I will participate in the trial, my lord. Any condition may be imposed. I will participate in the trial, my lord.
No. Want a dismissal or an withdrawal?
Withdrawal.
Withdrawal.
Obliged.
12.
With pleasure.
Yes. Where is the affair?
Page 16, lordship.
Yes.
Page 16, lordship.
Yes, madam. CD interim.
Lordship,
Highly obliged.
When?
CD lordship, 15th of May.
Considering the nature of allegation and the nature and gravity of the offenses.
15.
Highly obliged.
May please your lordship.
Yeah.
On the 430 application, my lord, FIR, my lord, is at page number 12. May I read the FIR? my lord?
CD.
Silly.
My lord, it's a property dispute, my lord. The informant, my lord, is the wife of the petitioner's brother.
We'll examine.
My lord, let him appear, my lord.
We'll examine. This is not a case. Specific allegation.
My lord, allegation is vague as such, my lord. No motive, my lord, nothing.
This is,
Let him appear.
this case is not for an interim.
Only 376, my lord.
My lord.
Actually, my lord,
Only 376.
26 and no
Only.
other section like trespassing and nothing, my lord.
So,
She says that, my lord, he
so
trespassed into her.
somebody has not laws registered any offense.
My lord,
Even after allegation, so there cannot be any
my
rape.
lord, my submission is that, my lord, the petitioner and the brother, they all live in the same plot with their
We'll
mother.
examine them.
Highly obliged.
Interim. No, sorry, CD, when?
Lordship, 7th of May, Lordship.
Seven.
7.
So,
7 May. this is
7th is a,
holiday,
Holiday. Then Lordship, 6th of May.
my lord.
not now, after some time.
May please lordship. For 430 application lordships, FIR is based 10 lordships.
Hmm?
430 application, FIR is based 10 lordships.
326 is there, Lordship.
Lordship
Is there, you will
Actually,
be
there's a
required.
counterbalance FIR lordships. We have filed our FIR earlier lordships and the petitioner's name is not in the FIR lordships. They are not named in the FIR lordships. Well, have a look at page 10 lordships. There is the FIR against us lordships,
Where?
page 10 lordships. And page 16 is the Barnacle lordships.
Page 16 we have read. This is the affair. And where is the other affair? Cross case you have said.
That is not page 22 lordships.
Page?
22. That is FIR lodged by us lordship.
And where is their affair?
That is page 16 lordships.
CD.
Our name is not in the FIR lordships. We have filed our FIR first lordship. There, later on they have come lordship, the countable FIR lordships. And these are land dispute lordships, clearly mentioned in the FIR lordships.
Land dispute, understand, we will not grant them also bail.
All belong to the same family lordship. All-
Maybe serious allegations of
No lordship, kindly see, this is a countable FIR lordship. We have filed our FIR first lordship. That is registered under same section lordships. Their case number is 22/24 and their case number 24/24 lordships. And these 4 days delay lordships, they have filed after 4 days lordships,
where is the date?
lordship.
The page number 10, date is 6/2/2024.
7/2. This is the affair where you are seeking bail.
Yes, lordship.
Page number 10.
Page 16,
Okay, interim.
lordship.
Take care.
I'm obliged.
Lordship, CD on Lordship, 16 May.
60.
I'm obliged.
Item 15,
Considering the fact that the petitioners have lost their FIR in earlier point of time and allegations are similar in both the affairs lost by the petitioner as well as by the informant. Oh,
My pleasure.
yes,
Allegations is under section 304, my lord. The FIR is at page 16. that I
interim,
took.
CD interim. When?
Lordship on 17th of May, Lordship.
16,
Obliged.
Yes,
26 and 307.
CD. And this. When?
Lordship on 6th of May.
Much obliged.
65. Supplementary list.
May I please, Your Lord?
Yes.
My Lord, this is an application.
Tell us two things.
My,
First is, you have cross-examined thoroughly, no whisper, even on the certificate, everything. Trial is almost over. Trial is over. At least the prosecution case is over. Why at this stage?
my Lord,
Why
the-
will not think it is to be have to fill up the electorate? And know why? What is the prejudice? You have cross-examined.
at the last phase,
Hmm.
they have introduced those electronic evidence not been given to us during the trial.
You have cross-examined
We have
that
cross-examined,
person thoroughly.
but the last, without those CDs being handed over to us, man.
But there is no whisper in your cross-examination saying that this was not given,
Sir,
nothing is there.
it was the duty of the prosecution to whichever the material they have relied,
Hmm.
they have to give it in beforehand, prior to our cross-examination. Prior to our cross-examination, it is the 207, they are duty bound to give all the relied material, even non-seizure document, if they are not
Yes,
relying.
we understand.
But this case, the whole case is based upon those material which have not been exhibited throughout at the last.
And another aspect, magistrate has, that district judge, session judge has not passed any order as such.
That is the thing, my lord. She ought to have
Ought to have
rejected it,
exercised.
explaining that it has been not given.
Any private respondent.
No, my lord, this is a criminal informant is there, but the only.
We think that the session judge should exercise its power and application is filed. It will give reason. We are not exercising power of a trial court. We will examine when a judicious decision or application of mind is given.
Yes, sir.
Isn't it?
Why this was not given?
Nothing is there.
Nothing is there, simply just because we have detail in our petition.
But you have made the informant party.
Not that's, that's the formal party, because it's between court and the petitioner.
This person has not assisted this or independently engaged any lawyer.
So only.
We'll dispose it off.
Yes, my lord, dispose it off.
Let the magistrate consider your application and pass a reasoned order.
Yes, yes.
We are not commenting on anything. Then we'll examine.
Fine. Fine.
If it
Yes,
goes
yes,
against
keep
you.
it.
But
Yes.
otherwise, why should we exercise it?
Naturally,
Mr.
that is our petition, that either you reject it with a reason.
Hard, Mr. A.M. Bora, learned counsel for the learned senior counsel for the petitioner, assisted by D.K. Buddha and also Madam Honorable Sunju. The petitioners are accused in session case number 78 within bracket NL/2021 and facing trial under section 302/34 IPC, which is pending before the Court of Learned District and Session Judge, Lakhimpur, North Lakhimpur. After the prosecution, after completion of prosecution witness, the petitioner, by way of filing an application under section 207 IPC, raised a plea that the material exhibits, Mr. Bora,
Material exhibit number
3, 4 and 5.
3, 4 and 5.
material exhibit number
M03.
just a minute.
MOP,
It will
three.
file logo, huh?
MOP,
MOP
capital M,
3 page 30.
4 and
Pencil
5.
mark. MOP 3,
4 and 5.
MOP 4 and
5.
MOP 5. It is the case of the petitioner that the PW8 exhibited certain material. What you say? It's material exhibits, namely MOP3, MOP4, and MOP5. However, those material exhibits were not served upon the petitioner at the stage of
207
at the stage of 207
or subsequently.
or subsequently. And therefore, for a fair trial, they are entitled for such copy of such material exhibits. Such application was, where is the order?
Page 33, my lord.
Come on, by
And 39.
page 39, by the order dated 22/3/2024, the learned session judge without dealing with the contention of the petitioners raised in petition number
84.
84 slash 284/24 dated 22/4/24 22/3/24 22/3/2024 কি করলো last time? Proceeded to record the statement of the accused under section 313 under section 313 CRPC. Full stop. Being aggrieved, the present petition is filed. This court is of the view that the petitioner has raised an issue by filing the petition number 284/24 as discussed here in above. And therefore, the learned session judge is under bounden duty to consider such application and pass a reasoned order, either rejecting or accepting such plea of the petitioner. However, the learned session judge has not dealt with the application filed by the petitioner, and therefore this court is of the view that the present petition is deserved to be allowed. Accordingly, is directed that the learned session judge shall take up the application number so and so, and here the learned counsel for the petitioner as well as the public prosecutor and pass a reasoned order on the application so filed.
Obliged. I believe the lordship. In last order, your lordship, the PM report was called for.
Is BA?
BA. Okay, ma'am. What about that?
Yes.
Well, as per my instruction from the IO, my lord, he has not yet collected the PM report.
28 days, your lordship, he is in custody. And
Where is
he
the
has-
FIR?
FIR is case 9, your lordship.
And what about the CD otherwise? How
Case
they
is
postpone?
available, my lord.
Give us. Show us what are the implications against this person?
He is the, my lord, husband of the, my lord, victim, my lord. And from the, in the FIR itself, my lord, it is specifically mentioned that the case is a case of suicide, but they suspect that the present accused has, my lord, killed the, my lord, victim, my lord. And thereafter, my lord, that PM report was called for, my lord. Today, my lord, contacted the IO. He stated that PM report not yet collected, my lord.
Now, what are the neighbors and all says anything? We want his custodial interrogation at this stage.
Because my lord, only he is suspected, my lord. The PM report will reveal, otherwise my lord, PM report is not yet.
The petitioner is behind bar since
Since my lord,
2020.
3 to 24, my lord.
3 to
24,
3 to
3 to, my lord. 69 days, my lord.
60,
69 days.
20 days.
3 to 20,
3 to
24.
24.
Peruse the materials available in the case diary. Full stop. The postmortem report has not yet been collected by the IO. However, the investigation otherwise is at advanced stage. The accused has also been thoroughly interrogated. Considering the material so far collected and also considering the period of detention, this court is of the view that no further custodial interrogation may be necessary. Full stop. Accordingly, allow to the satisfaction of
PM Kamrup Metro.
Kamrup Metro, 25,000.
All right.
Yes, that is returned back.
25.
25, my lord, case diary not received.
Not received.
The last occasion also they did not submit it. That
What
was
is the
purpose of
allegation here?
query.
FIR? Where is the FIR?
FIR, your lordship will find at page 12.
Page
12, 1, 2. Your lordship kindly peruse the FIR and to indicate, my lord, the allegations made are not possible. Villagers coming together for dacoities. The explanation given is that, my lord, there were, my lord, cow lifters, cow liftings happening in that area, and the police did not act upon. Maybe, my lord, they are hand in glove, and therefore the villagers, they were on a vigil, they were guarding. And, my lord, this type of vehicle, because they say, my lord, by this pickup van, they were going to a marriage from where to where, my lord, they have not stated. And that type
how
of
many days you are behind bar?
my lord, they have been arrested on 7th May
7th.
2024.
320.
And, my lord, the petitioner number 1, he is a, my lord, physically handicapped person. 50%, my lord, locomotor disability. That certificate your lordship will get at, my lord, page 16. The other petitioner about, my lord, aged person, 58 years. Your lordship will find Moni Borua, he is 50%, my lord, locomotor disability. They have named, my lord, only the
What are the offenses registered?
offenses, my lord. They have given almost all the sections of the IPC, my lord. 147, 148, 149, 325, 326, 336, 354, 392, 427, 506.
Yes, PP, what you say?
Otherwise, my lord, from the contents of the FIR, there are more of 100 persons, but there is specifically named.
That we understand.
Yes, my lord.
But you have arrested them. Period of detention.
Highly obliged.
To the satisfaction of?
Mm,
To the satisfaction of?
Kolyabor, my
SDJM, my lord, Kolyabor,
SDGM Koliabar.
Nagaon, Kolyabor, Nagaon.
I plead the lordship.
26 also, my
CP
lord,
was
case
called
diary
for-
not received.
75 days in custody.
What is the allegation?
Allegation 304B.
Where is the FIR?
FIR at page, Banakola at page 12.
Your husband?
Yes.
Yes, 75 days. When can you have the case diary?
Short date, my lord, I will try to get it.
This week only.
Yes, sir.
Maximum by
And,
Friday, not before that.
Friday, I will try to get.
Also, please.
May I please, your lordship?
Yes.
Not 54 days behind the bar.
Here also, my lord, case diary not received. Offense under
What is
section.
the allegation?
Page 10, lordship FIR. Is that it was received in the earlier date and it was accordingly paid.
But today it is not there.
My lord, I will get the instruction, my lord, after some time. My lord.
Okay, after some.
28.
I plead the lordship. I
Yes.
arrested on lordship 15/3/2024 lordship and behind the bars lordship for last 38 days lordship. Offense is 366 IPC lordship. The victim, white annexure 3 lordship was recovered lordship. Fact is the lordship, good relation existed between the petitioner and the victim lordship. Both the party lordship had been creating some videos lordship for entertainment purpose only lordship. And therefore,
Entertainment purpose. For whose entertainment?
lordship, due to this lordship, YouTube channel lordship, good relation developed between the parties lordship.
Hmm.
And therefore lordship,
16 years. It is there, Mr.
It is there.
What is her age?
As per birth certificate has been seized, my lord. Her date of birth is 23/3/2009.
Then what will be her age?
14 years,
15 lordship, yeah.
almost 15.
And what is her statement? No value.
Statement is not dangerous, my lord. My lord, she compelled to,
How many days?
he,
Lordship, 38 days lordship.
long statement. my lord. Medical, she refused medical. Look, I have flag marked that, my lord. I was noticed there. She was sent to GMCH, but she refused.
Stopped.
Considered. This case diary produced. Material so far collected reveals that the IO has almost completed the investigation. Statement of the victim has been recorded. Though she was taken for medical examination, she refused to get her examined by the doctor. Also considered her statement not implicated the considering the above present application stands allowed to the satisfaction of
At cesium,
Kamrup Metro, Guwahati.
Kamrup Metro, Guwahati.
Much obliged, your lordship.
Yes. Yes.
Acting council is kindly may not
Case for about 77 days. That thing happened here.
Why, how this man died?
My lord, the postmortem report could not ascertain the cause of death. And as per the accused person's my lord, version, he was drunken
Maybe.
fully. And he was sleeping inside the car for the night, because in the next morning he was supposed to leave for Pasighat by that vehicle. Special reports are not received, my lord.
How many days?
77 days, my lord.
But the material collected by the investigator, including the postmortem report.
Postmortem
we
report
need-
does not show any my lord, injury.
That's why I will not say.
External injury is not.
I will not say anything. We have perused. In custody since that is for last 77 days. Last 77 days. Good effect from which date? Forwarding report to Salem. 2-2.
5/2/24.
5/2/24. No, no, 2-2.
But he said, in the petition, he has some date of arrest 5/2/2024.
He was produced on 2-2. Page 17, is that it?
17. But I am showing from cause title.
Anyway, 2-2.
Hello.
That is for such and such a Silova. The material so far collected by the IO. After perusal of the material so far collected by the IO, this court is of the view that no further custodial detention may be necessary. Further custodial detention of the petitioner. Accordingly, present application stands. The satisfaction of Kamrup Metro.
Kamrup Metro.
35.
CGM Kamrup Metro.
CGM Kamrup Metro, 25. Tell your senior that bail is granted.
Highly obliged, Your Honor.
Yes.
And the bar, my lord, as on
Who was the
59 days. my lord.
first FIR?
That is at least 10, my lord.
Party, my lord, I am sorry, case there is not received, my lord.
9 days, my lord.
When Mr. Das?
Bhoyapuri. So it's 360 days to 60 days of it. No.
What is the period of detention?
It is
60 days.
306. you know.
06. Today is 59. 59 days. No search sheet is filed.
I do not know that. That instruction I do not have.
Just
My
have
lord, I will have the instruction.
today itself.
Yes,
Yes.
at 2 p.m.
At 2.
May I please, Your Lordship?
31 also, my lord,
439.
case there is not received, my lord.
439. Where is the FIR?
Fire at page 12, my lord. It is a moneylender's case, my lord. I am behind the bar for 57 days, my lord.
Islander, land grabber, what not? Where is the FIR?
FIR at page 12, my lord. The FIR has been filed by police personnel, my lord. My name is not properly mentioned, my lord, but as per the FIR, it is says that some persons lends money to the poor people and thereafter harass them. My lord.
But no such allegation from the individual against me.
Your name is?
My lord, Dulal Chaudhary, my lord.
26 ফেব্রুয়ারি পর আছে নাকি ছিল কিমান মান কেস আছে এটা
What your name is?
Dulal Chaudhary, my lord.
Yes, Mr. Das, what to do? Bank stamp paper. Why earlier petition was withdrawn?
তবে এসকে
26, 2020.
Why earlier petition was withdrawn?
Earlier petition I have
PA 757 of 24. Withdrawn on 13/3 to 2024. We have all details nowadays. Where is your statement?
My lord, about the withdrawn, I have no knowledge. my lord.
There is a bail application by this man. This matter along with PA 757/2024 is disposed of. See why? We'll take how many days you are behind bar?
57 days. my lord. This is a-
Totally 60 days.
my lord. Tomorrow.
Tomorrow. Oh, let him go. Why should we exercise all this?
I'm also not going to
Considering the period of length of detention. Your purpose is served.
No, not only my purpose,
Satisfaction of-
many others purposes have
SDM
been served by
Rongia.
these cases.
SDM Rongia.
Huh? SDGM Rongia,
Obliged, my lord.
50,000.
Thirty-two, also not case, there is not there.
My lord, already 52 days in custody, my lord.
What
And
is
if
the
I-
allegation?
If I may read out the FIR, Lordship will have an in-depth comment.
What is the
informative.
FIR?
Page
Page
14, Varnicular medium.
14.
So মহাশয় বিনীত নিবেদন এই যে যোৱা 26/10/2023 26/10/2023 ইংৰাজী তাৰিখে মই বাথৰুমত গা ধুই থকা উপৰোক্ত পদকে মোৰ অশ্লীল ভিডিঅ' বনাই লৈ মোক ব্লেকমেইল কৰিব আৰম্ভ কৰে। সেই মৰ্মে মোক বহুত হাৰাশাস্তি কৰি তেওঁৰ মতে উঠা বহা কৰিবলৈ বাধ্য কৰায়। তেওঁ ফটো ভাইৰেল কৰিম বুলি ভাবুকি দিয়ে আৰু মোক পইচা দাবী কৰে। মই ভয়ত তেওঁক প্ৰায় 2 লাখ টকাৰ সোণৰ অলংকাৰ আৰু নগদ 30,000 টকা পদত্যাগ দিওঁ। লগতে মোক ভয় দেখুৱাই মোৰ সৈতে শাৰীৰিক সম্পৰ্ক স্থাপন কৰে। গতিকে
Das city is there.
City not there.
the incident occurred last year. Where was she all this time?
Maybe. So that may not be a ground. That may not be a
That
ground.
delay may not be gone.
Delay is not a, suppose he is under, suppose it's a genuine case. Somebody is being blackmailed. It will make your, a lady will definitely will not lodge an affair.
My
That
lord,
cannot be the ground.
was
But
all
reading the affair, it's,
it was all consensual, my lord. Nothing is there. They had an extramarital
but
affair.
consensual is also having a difficulty here. Have what you want to have your measures. But threatening to viral, make the photographs viral, that is the private photographs, private moments. Nobody is bothered. What are you doing inside room?
Okay, my lord, but thing is this, the informant's house is
That
totally.
cannot be an offense. But moment you threaten that I will make it viral,
What made her wait for all these months, I mean, since October?
made her wait because that you have taken advantage of her weakness and now you are blackmailing her. That's why she waited. Finally, when her monies are exhausted, now she has come. Yes, Mr. Das, what to do?
My lord, I may be given a chance. my lord.
Okay. When?
52 days in custody, my lord, young.
Let him have some experience there also. Yes, 60 days. It is 60 days.
No, 376 is there. my lord.
376 is there.
So, my lord, 2nd of May, my lord.
That cannot be invoked. my
Second
lord,
of May,
376.
okay. Be there, be in peace for some
Short
time.
date,
Let other also be in peace for some time.
short date.
Give a short date, Mr. Das.
So at best 30 million. 30.
30.
Election is going on, my lord. That is why we cannot pressurize people. also.
Festival of democracy. You'll have to respect it. Yes.
Always.
Please, Your Lordship.
Yes.
Charge sheeted matter. FIR is at page 12, type copy is at page number 14. The,
Perhaps scan copy is not received here. Scan copy call for us.
No, it is ought to have been in the motion
yes, Your Lordship.
because on the first day he did not
He
appear.
could not appear.
Heard learned counsel is in application under Swens. All
Scan copy
for
call
the
person.
scan copies
Warning.
of the record as well as the case diary of which case?
PS case number 7 of 2015.
7 of 2015. Which from the learned from the which court?
Special,
Additional
session
from the
judge
court
FPC number
of learned additional session judge number 4 Kamrup Metro Guwahati. Seated accused facing trial in case number
254 of 2023.
Where do we get it? Okay, sessions case number 254 of 2023 pending before the learned additional session judge pending before the court of learned additional session judge Kamrup Metro Guwahati.
Notice upon respondent number 2.
Accepts notice.
One.
The respondent number 2. Third post as well as to usual process within 5 days.
Deeply obliged.
Item. Yes.
Lordship, the mother of the accused person, Sri Abhishek Boro.
Where is the FIR?
Page number 10, Your Lordship.
Yes, ours.
The case is already has evidence stage. Case is committed before the
Charge
additional
sheeted.
session just told.
Why you have withdrawn the earlier
Yes, this is-
What do you withdraw also?
No.
this is 1042, is not it?
1042 million.
10 copies not received. The scan copies of case record called for by this court under its order dated 9/4/2024 had been received. Registry to issue reminder to call for the case record of sessions scan copies of case record of sessions case number 231/2023 and also the copy of the case diary in connection with the Bokishta PS case number 474/23 from the court of learned
Additional
CGM
session judge number 3.
additional
Session judge number 3.
additional session judge within bracket FTC number 3 Kamrup Metro. list this matter on 20.
20th May, pardon.
Thirty-four, my lord, case diary is not updated, my lord, petitioner is an interim, my lord.
Okay.
Statement is-
The learned additional public prosecutor submits that he may be granted 10 days time to get an updated case diary. Prayer is allowed. List accordingly. Interim order passed earlier. List accordingly on 3rd of May. Interim order passed earlier shall continue till the next date of listing.
Can it be on 6th or
7th of holiday, 7th of May is a holiday. Also, it's doubtful because of election. I think it should
any
go.
date except 3?
Huh? 9th.
36, 37 of the same affair. So, Lord, kindly look at item number 37, my lord. Last day, argo 35, 36, 37 of
First, tell us their status. These are item number
37.
30.
35, he is the, my lord, ADC.
35 is revenue ADC.
Yes, my lord. 36, he is the executive, assistant executive engineer, my lord. Roads, my lord.
Okay.
He is the assistant executive engineer, Roads, Moscow subdivision, where the incident took place, my lord.
And what
30
about 37?
37, he is the assistant executive engineer, Roads, Hemazi subdivision, my lord, where not anything has been happened, my lord. Now, I want to show something, my lord, to your lordship, my lord.
What is that something?
I want your lordship kindly go to the FIR, my lord.
Item 37, 6.
37, my lord. Case, my lord. 14, my lord.
Is 14.
Yes, my lord. Last part of the FIR, my lord. We came to know that an additional deputy commissioner is inquiring into the matter on the basis.
I'm at page for
Item number 37, 4029 of 2023.
4329.
Yes, my lord.
Page
Case 14.
14.
14, my lord.
Okay.
16/10/2023, my lord.
Okay.
Earlier, he has filed a complaint before the DGP. On the basis of that inquiry has been done. He said that effect should be given to that, my lord. We came to know that an additional deputy.
Where are you reading?
Last part of the page 14.
We have come to know.
We have come to know that an additional deputy commissioner is inquiring into the matter on the basis of our complaint. Therefore, it is humbly requested you kindly register a case to conduct unbiased investigation into the matter, being to the official get in the justice. So, lordship, kindly come. I shall want to produce some document, my lord. Kindly go to it. Earlier, I also produced, my lord, that, my lord, assessment. Name of the work, assessment of building and other structure falling at the site of proposed PW road from Telijan to Machkua under Assam Mala project. Here, my lord, your lordship found the signature of PWD building, my lord, assistant PWD building and junior engineer PWD, my lord, Themaji territorial building subdivision. Then your lordship come to the, my lord, inquiry report, my lord. Third page.
Where is that inquiry report? Third page.
Third page, my lord. Have your lordship got it, my lord?
Yes.
Inquiry submitted by Biswajit Sekar, ACDC, my lord. Government of Assam. Have you also got it, man?
Yes, yes.
Government of Assam project title Assam Mala for widening, improving state highway, the road, Butikul Tiniali, Thokwajana, Telijan, Dhemaji project. The affected person approached Guwahati High Court, so. A joint verification was conducted, Circle Officer Dhemadi, PW the RD, and my lord, and based on the report, has submitted assessment compensation against 20% affected party, so. Subsequently, based on 50% compensation was paid to the accused person. On 20 Minutes Committee and submitted a complaint, Public Accounts Committee alleging anomalous assessment compensation present inquiry. Document consultant, assessment chief of individual structure submitted by executive engineer PWD building. That is important, my lord. That part is important, my lord. Net land record, my lord. I am the assistant executive engineer PWD roads, both the my lord. Jonaram Dole, and Nirut Sang my board. Jonaram Dole even not working in that division also. Statement recorded, my lord. Recorded Pankaj Mohanian, Sunil Dolo, Lobos Honwals, Nirut Sangmai complainant. The right of way acquired was the in presence of a PW user agency. PW road has been used as an user agency, my lord. Circle officer, alert staff, affected person. Land record or consultant measurement were taken in the presence of affected alert staff official. Aqua structure were identified alert staff, Gaon Panchayat and my lord, geotech photograph, my lord, of the structure were taken. Aqua structure remeasured user agency affected person alert staff. Physical made on 13/6/27/17 during verification. It are found person of whom assessment is prepared are bona fide pattadar. Their name are recorded of the land. No discrepancy was observed in this regard. My lord, the particular work has been executed by both the petitioners, my lord, for my lord, right of way of the land, my lord. That was done as per my lord direction of the wall BAM. There is a specific my lord direction. On the basis of that, road has been my lord, right of way has been surveyed, my lord. And so far, my lord, building concern, we are not involved. The assessment were made 20 structures submitted by EEPWD building. Have you also got it, my lord? That was yes, my lord. And found erroneous 2 ways. Erroneous assessment of acquired structure, assessment unequal non-existent structure. Some structure remeasured the following discrepancy were found. The structure Relac was assessed so my lord. Structure Saran Datta mentioned, my lord, but the discrepancy was there. 3, my lord, exact. The measurement of affected person like Pankaj Yan, my lord, who is released on bail. Mohan Yan, Omulya Soika, Biren Soika were found exaggerated and erroneous. This Pankaj Yan is already released on absolute bail, my lord. When bail was absolute, my lord, only on the ground he is cooperating with the investigating agency. I was, my lord, thoroughly interrogated by the Dhemaji police station. Subsequently, I was interrogated by the, my lord, CM Vigilance Cell, my lord, in this case, my lord. Next finding. The finding of the inquiry are summarized as below. The affected have already paid 50% compensation amount. No further should be paid until the assessment, reassessment structure. And my lord, 3, my lord, whereas the affected person, Pankaj Mohanian, Jantakas Amulya Soko were admitted in the statement, the scope error in the assessment, they are already accepted. Reassess if so.
Pankaj Mohanian is the main.
He is the main person, my lord. I argued at that case also, my lord. When I argued, the court said he is cooperating with the investigation, satisfied his bail has been made absolute, my lord. That is the, my lord, ground. I said, my lord, I was thoroughly interrogated by the, my lord, both by the Dhemaji police, my lord, as well as CM Vigilance, my lord. And my, if you look at the parity, my lord, actually, there is no allegation against this petitioner. So far, report is concerned, my lord. So considering all these things, my lord, your lordship, my lord, kindly made my interim bail absolute, my lord. I can show from the list I argued, my lord, after here.
Made please, your
So
lordship.
parity with whom?
Yes, parity with Pankaj Yan, my lord.
So
Pankaj Yan,
how can there be parity? That means you and Pankaj are hands in glove, same footing.
Same footing, my lord.
he is more
But-
bad footing, my lord.
But
Then where is the
fairly
question
submit,
of
my lord, he is
parity?
in less footing, my lord. But if you go by parity,
Where is the parity
difficult
question?
for him, my lord.
Huh?
If go by the parity, my lord, then it's difficult for him, my lord.
So that's why he's arguing parity with a person who has been granted bail under 439. So we have given him the option, you surrender and we'll give you bail on parity. That was his first argument, parity. Now he's arguing parity with this, so we'll have to say that you are also involved.
My lord. Here, my lord, these 3 accused, my lord, there belongs to my lord PWD roads. It's correct, my lord. And they have admitted.
No, this
One is
One
ADC,
is
yes,
ADC.
Utpal Dole is ADC. Here, my lord, they have admitted that, my lord, they have doing assessments and demarcations. No doubt their firm belongs from the PWD, but on the instructions of Utpal Dole, these two other accused persons, they have doing the assessment and demarcations. And the two businessmen, one is my lord Chintu Soikia and the informant Minturas Kaman implicated this accused. They said that yes, they are in the assessment and they have misappropriated the such and such a huge amount of which was on the scheme.
I think that ADC will have not a role in actual assessment. He may be aware of this because ultimately his role will be different. He cannot, because allegations is, even if we go by the inquiry, allegation is that in one case there was an Assam type house, it was assessed to be two-storied building. Now who has done this?
Yes.
If Kaman has done this and he has been granted bail, they are cooperating. Let them go.
My lord is correct. I am not, my lord, my lord, I agree by your lordship's, my lord, query. The one Lobo Sunwal, he is also one of the co-accused. He stated that under the instruction of Utpal Dole, he assessment and the measurement is said area.
Utpal Dole is?
ADC, my lord.
Utpal Dole is ADC.
Ah, yes. Under his instruction, the
he has said that you do assessment.
my lord, they are cooperating, my lord, because I have, or there is no other specific allegation regarding the misappropriation of money.
That is what I asked you.
Yes, only, my lord, the case that reflects, they are, my lord, demarcating an assessment.
Why should we grant you privilege?
My humble submission, I will, my lord, at that time.
This is a privilege and it's a public money.
Yes, sir. If I am not involved in the misappropriation of money, my lord, I done, my lord, survey, my lord, on the road only, not building, my lord. That is, I am submitted. In my statement also, my lord, I have stated all these things.
You have stated, but others said that you have.
But if you look,
I think it's not a good case for bail.
Lordship, kindly look to this document, my lord. Why I surveyed the road, my lord. So, Lordship, go my statement, my lord.
Considering the material available so far collected and also considering the fact that petitioner has cooperated with the opinion of this court, custodial interrogation may not be.
Much obliged.
But don't argue parity with the in 438 case with 439.
Yes, my lord.
Then we'll allow your parity and ask to surrender.
Yes, ma'am.
Yes.
Interim order meant absolute, my lord.
These are
We have granted bail, what interim order is absolute?
much obliged.
Musumi.
May I please ask?
Yes, Mr.
This is 438 in a such case. Earlier, lordship was granted interim on 22/12/23, no coercive action. A scan copy was called for. Only my apprehension is that because of the Sessions Tribal case, because of 209, I may put behind the bars. Make it absolute. I'll definitely face the trial. Because rest of the accused person, they are appearing. Only these two petitioners, they were not there. Warrant was issued, that was recalled. Now they are on interim.
Now what to do today?
That interim may be made absolute because scan copy has come.
Scan copy has come.
Scan copy received, my lord. I have flag marked the order of the, my lord, trial court after obtaining order of no coercive action, my lord. The order dated 28/12 and 19/1, your lordship may kindly peruse.
This order dated?
28/12, initially on 23/6/21, he was shown as absconder in this house. Thereafter 28/12/23 and 19/1/24, last two flag marks, my lord.
28/12 first one.
991. Okay. তুই করি absolute করি।
আচ্ছা।
Dispose.
Lordship.
39, my lord, case diary not received, my lord. He's in interim.
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 When? Next,
On my lord, 15th of May, my lord.
15th of May. Interim to continue. Yes.
Terminology appeared. Page 9 is the affair.
Case 9 is the affair.
He appeared, my lord, statement.
Appeared, considered the material, cooperated, আছে না আগর order. You will need to spend a paper, the ink. You will have to maintain an office. Yes, Mrs.
My lord, 41, just now I have received that
now?
after some time, my lord. May please, your lord.
Yes. Who is the affair?
Vernacular page 13, Lordship. And
1-3.
1-3. Typed copy, Lordship, page 9.
Consenting.
But my lord, and now
Succeeded.
and he was shown as absconder. My lord. That is where
This is AB or what?
this is AB, my lord.
10 copy received, I think, Lordship, one last.
10 copy received and was thoroughly searched in his house, my lord, but yes, my lord, not.
Now what to do?
LCR portion, Lordship, my kind last portions, my lord.
Your bill was rejected or what earlier?
Rejected.
Uh,
Rejected before.
in
Trial
sessions.
Go and appear where not. If it was rejected, then you have not come to High Court. Now we cannot grant you an anticipatory. Withdraw it. Will not pass any order. The learned counsel for the petitioner submits that he may be allowed to withdraw this present application and approach the learned trial court for regular bail. That it. Prayer is allowed in the event such application is filed. The learned trial court may consider. Yes, as per law.
Please, your Lordship.
Admission করি।
Yes. Here, my lord, I have filed this PDRS bail application. In note, I have found another application of same person. It is my duty, my lord, being,
Is this matter along with AB 985/2024.
Maybe 985 million.
985 of 2024. When?
9 fixed the other.
I will take it before that. That date will stay along
Day after.
day after tomorrow.
It is there.
That's why. Nowadays, all these are
My lord.
On entry, my lord, here,
where is the affair?
this is basically a cross case, my lord.
No,
FIR
cross
will-
case, to be cross case, there must be a
Yes, yes, my lord.
case, that
Page
is what we
15,
are
my
asking.
lord. Page 15 is the affair against which I
15.
have come, my lord.
Here, my lord, CD not received and they are on interim, my lord.
Interim.
Yes.
When?
My lord, after 2 weeks, my lord, any date, my lord, on 10th of May. my lord.
10th of May.
45 also I have same pair, my lord, on interim, my lord, CD not. received.
Item?
45.
Okay, same pair. Tell him to continue.
Obliged.
Lordship, in 46, Lordship, scan copy is there, but up to date scan copy will be required, Lordships.
What
status
is the
report.
issue here?
I am succeeded matter lordships.
The absconder, Lordship.
Absconder, page 10 is the affair lordships. I am not naming the affair lordships. The message which is
You are
Yes.
not naming affair.
lordships.
But all the witnesses have said against him, Lordship.
No, my police, I am ready to appear before the trial court lordship, but police never visited my house, nor they tried to arrest me lordship. So when someone has come to me lordship, then only I came to know lordships. So kindly have a look, the page 10 is the affair lordship.
Page,
10, Lord.
page 10 of the,
Page 10 lordship.
of your petition.
Lordship, lordship. Petition, lordship. The type copy lordship.
Relevant portion is in 18, Lordship, page number 18, Lordship.
No. Motion also took place lordships. It to appear lordship, kindly some protection will be granted lordships.
Page number 18, Lordship, last paragraph, during investigation, the SIM cards, which number were,
That does not belong to me lordships. That's that phone number.
whole planning was done by absconder accused Momin Ali.
But later on, however, last line lordships. The estate accused person did not unveil the name of the businessman lordships. No incident took place, nothing has been done by the petitioner lordships. Suspicion. Need to face the trial, Lord, I prove my innocence.
Everybody is ready to face that trial. That cannot be the ground.
It's true, Lordship, but
If that is true, don't argue that. Everybody is ready to face that trial.
the affair also, my name is not.
Can that be a ground?
Lordship.
You are repeatedly
And
arguing that.
police also not visited my house, lordships.
Your name is?
Momin Ali.
What is this page 30?
30 lordships.
What is this?
In similar situation, lordships are
Same case.
no lordships. In other case, lordships, when such submit as an abscondal, sorry, abscondal lordship,
What is the ratio laid down here?
not lordships.
Huh?
Or High Court lordships, in some cases, lordships granted some this kind of order lordships.
What is the parameters in such a case to grant bail? Anticipate.
That is not lordship. That is not.
No, no. What are the parameters so that we can pass an order? The grounds you are seeking cannot be grounds for granting you anticipatory bail at this stage. Is that it? The material so far collected says that you are the kingpin on whose instruction these people tried to execute a plan of kidnap. These are the materials. We do not know. That may be correct, may not be correct.
That is true, lordships.
Now, what should be the parameter to grant you an anticipatory bail at this stage?
Your lordship,
Now,
kindly-
otherwise, everybody will be absconding. And after that, they will come, since trial has become, what is the question of arresting me? Can that be a reason?
that is not lordship.
If not, what should be the reason? Tell
Well,
us. We know nothing.
Lordships. You all kindly have a look at page 10 in the affair. My name is not in the affair, lordship. Only some.
The allegation is such that they were also in the dark at that point of time. They say that there is a plan to kidnap a person. Okay?
Yes.
So accordingly, a message was sent that there may be an attempt to kidnap.
Yes, lordship.
Then they swung into action, arrested some person.
Yes, lordship.
Now those person have said that yes, we wanted to kidnap a businessman. And this was done at your
No, no. The arrested accused person did not mention the name of the any
no
person.
name, no name.
Yes, that is. Yes, lordship. If it is true, lordships, they could have mentioned the name of the person. So, do
Cannot decide this true or fake.
on any condition, lordship, your lordship may grant bail, my lordship.
Is the problem.
That-
At the end of the day, we will argue any condition.
Yes. He may be acquitted, lordships, in if he faces the trial, lordships. If it is so, then if he would bend the bar, lordships, no purpose will serve, lordships. Justice.
And go through the case diary and show us any attempt was made or in except their statement. He has recorded that somebody has named. In the case diary, show us any attempt was made during the investigation to arrest him or to do something. That's all. This should be your argument.
And we'll have to bring
No, case diary is here.
Yes, there is there, but it is not in serial position, lordship. I have gone through, lordship.
Go through it. Dates are there. 2:30 p.m., 4:10. If that is not there, somebody has named, you will not attempt anything, then he cannot be declared as absconder. Then we will give him protection.
I'm available.
Yes.
May please, your lordship. 38 application registered under 302, my lord. FIR is at page 12.
438.
438, my lord. The petitioners here are the in-laws of the deceased, my lord. They are contending, my lord, that of suicide, my lord, not of murder. They are further contending that they have not contributed to suicide. Otherwise, case diary is here, my lord.
Case diary is there.
Case diary is there, madam.
What the postmortem
Madam,
report is there?
postmortem, madam, perhaps it is in seal envelope. I lost his permission.
Postmortem.
Yes, may I
Okay,
open?
okay. After some time, you just go through it.
Thank you so much. Lordship, this is 438 bail application, Lordship. Matter is pertains to FIR is page number, Lordship, and 13 is Lordship Barnicola.
13 or 12?
12, sorry, Lordship, 12. Read, Lordship. পূর্বক বিনীত নিবেদনে যে মই শুনামতে মোৰ ডাঙৰ ল'ৰা ইমানালীৰ পৰা নিম্নলিখিত পদকীয়া গুণে কিছু টকা পায় কিন্তু যোৱা ইংৰাজী সহিংস তাৰিখে অনুমান 3 মান বজাত মোৰ ঘৰত আহি মোৰ সৰু ল'ৰা নুৰুদ্দিন 18 বছৰ
Yes, there is there.
Is there, my lord? Here, my lord,
What is the now?
now, my lord,
It has recovered?
yes, he was kidnapped by this petitioners, my lord. And as per the witnesses also, my lord. And after that, my lord, he was again, my lord, in a market, my lord, he was kept dropped in the, and they fled away, my lord.
What is the statement of the victim?
Victim statement is like that, my lord, because they took him for giving, my lord, a cup of tea, my lord, after that.
Kindly again come to page number
And
12,
this is
Lordship.
also supported by some of the witnesses who
Just
were.
give me, huh?
First 3 lines, Lordship. 12, Lordship. সন্মানপূৰ্বক বিনীত নিবেদনে যে মই শুনামতে মোৰ ডাঙৰ ল'ৰা ইমানালীৰ পৰা নিম্নলিখিত পদকীয়া গুণে কিছু টকা পায়। What happened in this case, Lordship? The elder son of informant, Lordship, has taken 2 lakhs rupees from the petitioner's, Lordship. After that, Lordship, the petitioners informed to the informant to return those monies, Lordship. But they are not returned to the monies. When, Lordship, petitioners comes to the house of the informant, Lordship, then they are started some odd actions, Lordship.
Very good. You kidnap and file 438 application.
Yes, Lordship.
Thanks God that he is not still in your custody.
But in this FIR, Lordship, clearly mentioned that some money has been taken from the petitioner.
Maybe will
Yes, Lordship.
that permit you to kidnap the?
No, Lordship.
Huh? So therefore, we'll look into the statement of the victim. Perus, the case diary produced. The informant has alleged that younger son of the petitioner was kidnapped by the accused person and they demanded a ransom of rupees 2 lakhs. The statement of the recovered victim clearly depicts that the accused person kidnapped the petitioner and demanded the money as alleged in the FIR. However, subsequently, when FIR was lost, he was the victim was released and police recovered him from a market. Considering the above material, this court is of the view that this is not a fit case for grant of privilege of pre-arrest bail to the petitioner. Accordingly, the same stands dismissed. Case diary be returned. Yes.
To give justice, Lordship, we have trying, but we cannot, could not. Therefore, Lordship,
Seated.
so we have been declared absconder by the police.
I have, my
What is
lord,
the
kindly see, my lord, kindly see the 164 statement, my lord, that is there in the LC. I have flagged up 164.
Enter, Lordship, page 31 is the.
কৰা নাই নেকি এতিয়া? কমিট কৰা নাই কেছটো? Clear কৰিছে? ইন্টাৰিম অৰ্ডাৰ আছে দেখোন। চাব লাগিছিল তাতে যোৱা নাই। সেইটোৱে যোৱা নাই। কোৰ্টত কৰিব লাগিব।
ঠিক আছে, আজি টাইম
ইমান দিন কৰি আছে।
So we basically pass the earlier order on the ground that it was a promise to marry only. But she has specifically stated that how you have raped her. So
And another thing is that, my lord, interim order is there. He has not appeared till date, my lord. As a result, perhaps the case could not be committed to the Court of Sessions.
There was no specific direction to appear.
Hard.
No, Lordship, I'll just point out one. Lordship, at page 27
of
the petition, settled at 25, Lordship.
material is clear. You are a married man with children.
Yes.
She is a girl of 18, 19 years. She said, yes, I had an love affair. Then he took me, I accompanied him. But he raped me against my will. And later he said that I cannot marry you because I am a married man. So that intention is clear.
And both are 161 and 164 statements are same. Tito.
Lordship, charge sheet has been filed. Therefore, Lordship, will kindly come to page 25 for once. Lordship, as per the medical report,
yes,
there is no evidence of sexual assault that is there in the medical report. And at page 29 and 30, the dispute has been settled before. Dispute has been settled, and then now they have entered an agreement before the notary Dibrugarh. And the
that
case
is
case
that
trial.
will be a further ground not to grant you anticipatory bail.
I'll face the trial. I'll
Hard.
Lordship may send me back to the trial court. I'll apply it there.
The case could not even be committed, my lord.
Hard. Mr. Learned Counsel for the petition. Dated 89/2020. First paragraph, second paragraph. Third, fourth. Good. In the aforesaid backdrop, this court called for the statement of the victim girl recorded under section 164 CRPC and 161 CRPC. Them has been produced and perused. The victim girl has specifically implicated the petitioner in committing the rape upon her. Of aforesaid, this court is not inclined to grant, inclined to further continue with the interim order passed earlier on 18/9/2023. Accordingly, same stance vacated, and accordingly the present application dismissed.
FIR Lordship, page 7, Lordship.
68 my lord, case there is not there, my lord. Thanaidu, Bigfoot.
For allegation only attempt was their lordship.
So their attempt is not an offense.
There was no.
Do you agree? Then we'll record that you said that only it was an attempt. Attempt is
Affidavit of the information is 12 and 13.
face.
12 lordship.
Itu. Bilebi. Kuna kursi.
Do not know who has done what. Yes, Mr. Dasman.
Every day we are coming across such type of affidavits in rape cases, my lord. If rape has happened,
Two
if
aspects. One is the color of rape given subsequently, being
Yes.
caught. These are major. We do not know. So therefore, case there will see. But allegations are there. Therefore,
yes,
when
not 8th of May.
8th of May. Yes, where is the affair?
Lordship, here scan copy is received, my lord.
Go
I'm
through it.
sorry, I could not go.
Go through it. Go through it.
I examined the 67, but I could not
The-
examine
the
69.
Scan copy call for has
Let it day after, my lord, let it come.
dust learned additional some time to go through the scan copies. Mr. Priya Rizala, please this matter on Friday. Yes.
But yes, my lord, in this case, as per my instruction, earlier CD was available but sent back for updation. So my lord, today.
This
CD
is an
not-
interim.
BA.
BA, my lord, no.
Put within an application.
Oh, this is BA.
Today is 55 days.
What is the allegation?
Allegation is under section 376. Type copy of the FIR is at page 10, lordship.
When, Mr. Bothakur?
Try to get it
Can
on.
submit. Actually, there was a love affair between the petitioner and the.
That is what we want to know from the case diary.
26, my lord. 26.
Case on 25, lordship.
I'll
Have
try
it,
to
have
get-
it, we'll see her. Exaggerations are there,
Yes, ma'am.
but we do not know.
One earlier case. was
Ah,
also
that's why,
received.
that's why.
Yes.
Let us see.
41, my lord. Yes, I have received, I have gone through the case very my lord. Lord, in this case, my lord, two case diaries were earlier called for. But as per my instruction in my lord, NLPS case number 24/24 filed by the petitioner. In that case, my lord, already search sheet submitted. My lord.
Okay.
Today, my lord, case diary is available with me is my lord, the present case, NLPS case number.
What is the
25.
affair?
My lord, affair that is 21.
20.
21, that was the subsequent affair. Affair was earlier in
Where is your, where a subsequent affair?
Subsequent FIR is at page 21. For accused persons. Respectfully, I beg to state that opposite parties are their relatives. Yesterday, I told him to go alone. I will go with the house. Dog was sitting on the road through which I was coming. As the dog started barking, then my brother told, "I am not thief. Bark to the thief." Hearing the sound of my brother, the opposite party number 2 came and had beaten by saying that to whom he was referring to as thief. Thereafter, my lord, your lordship will kindly read this sentence, my lord. Thereafter, 3 other opposite parties came in while assault was going on. The OP number 1 assaulted my brother with sharp weapon, causing injury to his head, hand, body, and fled away. So, my lord, the accusation again, my lord, against the OP number 1, that is, my lord, petition number 1, that only, my lord, attract 26. The others, my lord, it does not.
Now,
kindly
where
see-
is your affair?
My lord, my affair is at page 11. That was lodged on 5th of February 2024. The other affair is on 6th. Parties are injured in the affair against us, my lord. That, my lord, 320. Petition number 1. And the other petition, he is working in Jal Jeevan Mission. Petition number 4. 58 years old. He is a driver in soil department.
Petitioner.
4 petitioners, my lord. Jahan Ahmed. Also, my lord, working as an instructionist in 2. He is working in Jal Jeevan Mission. Petition
Who is
number
this?
3.
Yes, my lord, case diary received, my lord.
Who is this?
That has been, my lord, given in the.
On that day, actually, they my affidavit.
50.
5. One day.
Page number लिखा.
Had one finger.
Why these two affairs are not investigated together?
Same incident, my lord.
My lord, now, as per regarding that, I will have to get the instruction, but my lord, as per my instruction regarding NLPS 24/24.
See, same, in fact, there was a scuffle, right?
Yes, my lord, definitely, my lord.
Forget about for the
Yes,
time
please.
being.
Yes, my lord.
Same incident, 2 affairs.
Two
were there.
affairs, my lord.
How can there be 2 criminal cases? Maybe, but it should be, charge sheet should be for either charge sheet or whatsoever. They should conclude together. So in the case where she lost the FIR, he lost the FIR,
Right.
charge sheet is
Charge
filed.
sheet submitted.
And nobody was
The
arrested
present
here.
case, my lord, case diary is with us, my lord, from the
He-
earlier.
He was.
Nobody is arrested, my lord.
There nobody was arrested.
Out of self-defense, he kicked. And thereafter, he ran to the house and entered there. And thereafter, also they chased.
Are you on interim?
My lord, and
Now
after
these,
they made
these,
my lord,
who expired?
my lord, because
These are
of
not
this.
relevant facts. Facts is that there was a couple between two parties. Now, apparently injury inflicted upon,
Right.
we do not know about what.
Right, my lord, we have also filed in the my lord affidavit where my lord, your lordship may see, my lord.
So there was this couple. In the other case, what happened? No arrest was made.
Yes.
Where do we get the scan copies of the case diary of the other case?
Okay, that my lord is difficult for me to say because my lord that from the registry my lord that will have to be sheet submitted in that case my lord.
I want to see that also.
Regarding the present case, my lord, I have received 2 injury report, my lord, and my lord statement of
Those injuries are relating to this case.
this case. My lord.
Okay. So that may be that will be a vital consideration.
Yes.
No doubt about it.
Yes.
What is the portion of the body? What kind of injury? So at the same time, we want to see the other injury.
Yes.
For 323.
Maybe let us see the
Allegation is against the petition.
No, that may not be because if there is a common intention and all, every individual's role may not be necessary. Is not it? But this is a little bit injury serious, no doubt about that.
Injury is serious, my lord, both sides also.
And your story is that he got injured himself, but that injury cannot be.
That, my lord, I am not.
That cannot, because FIR says so. That cannot be. What to do?
Your lordship, one
Otherwise, on this case may not be a case for anticipatory bail. And
Your lordship sees
sees
my lord
that
report.
that much. That is my view. So a fair chance should also be given to you. And you are not on interim. So we can. From whom case number? From which court?
Not looking for my lord.
Sessions court or magistrate?
Magistrate court.
Chief Judicial Magistrate. Case number?
Case number, my lord, 24/24. Search sheet number, my lord, 41/24.
The registry. This court is of the view that for proper appreciation of this case, the case diary of
My lord, NLPS case number 24/24.
North Lakhimpur Police Station case number 24/2024 shall be required. It is submitted by Mr. Bothakur, learned additional public prosecutor, that in the said case already a search sheet has been filed, being
Search sheet number 41/24.
under section
No, my lord, section not mentioned. Here as
Got
per
record because I have been.
submitted accordingly. Submitted in connection with GR case number or PRC.
GR case number is only, my lord, I have the search sheet number.
That is necessary.
If I GR number.
PRC case will be necessary.
GR will be there.
The FIR it should be there.
No.
GR 79/24.
24.
PR case number
79/24.
79/24 from the learned Chief Judicial Magistrate, Lakhimpur, not
Lakhimpur.
Lakhimpur.
Poor, he's a 58 years old person.
What do you say, Mr. Chaudhary? 58 not a age.
So, my lord, the other two are his sons. They're fighting, my lord. father
Just
may be
wait for, give a date, give a date. Registry stood forthwith call for such scanned copies. 17th of, too long. Let us try with 10th of May.
Well, date of search it is 23/3/24.
23/3/20.
Lordship, I have flagged it and
Where is that?
first. I have charged him.
They have been searched. These are a witness, everything is there.
My instruction, police never visited my house, Lordship.
That is on record, therefore we have said, we reject it or you approach for regular bail. Learned counsel for the petitioner submits that he may be allowed to withdraw his present application and approach the learned trial court for bail. That is allowed. Accordingly, that is the on withdrawal.
7.
Here, my lord, the incuse report has been sent, my lord. It is not the postmortem, my lord.
What the inquest says? Injury
In
mark
case, my
and
lord, there is no, only the oblique mark, my lord. And there is a note, my lord, that the viscera is sent for the forensic report, my lord.
this is anticipatory bail.
Maybe, my lord.
When can you have this?
My lord, on 3rd of May, my lord.
3rd of May. 3rd of May for the updated case diary, for the postmortem report.
Deeply obliged.
Request for the petitioner on later after a week.
The last order, my bail application is pending. We have taken step, my lord. Actually, my lord, as per my lord notification, my lord, I have got, my lord. Copy should be served to the, my lord, victim, guardian.
This is for criminal appeal.
Criminal appeal, my lord. He was convicted.
Why this is listed today?
It was listed, my lord, you also kindly peruse last order. But it is, bail application is pending, my lord. We served the copy to the informant, my lord, who is the actually guardian of the girl, my lord. Because father, mother expired, as per evidence of PW2, my lord. As that this order has been passed this honorable court, my lord. I have gone through the judgment, my lord. So also kindly peruse that, my lord. That judgment which has been mentioned in the order. Guardian is the, my lord. So, my lord, we can serve copy to the guardian also, my lord. কপি দিছো 3D লৈ আহিব দে। দিছে objection.
Yes, Goswami, there was a direction that jurisdictional police officer shall furnish a report to the officer of the public prosecutor as regards status of service.
That report, madam, and
To the public prosecutor. There was a direct, any information? Or whether
right
it was?
now I have no information. I'll produce the report, madam. Kindly, madam, section is also not filed, madam.
In terms of this court's order dated 18/3/2024. Goswami submits that he granted 10 days further time, obtain instruction as regards service upon the victim in terms of this court's order dated 18/3. That is allowed. In the meantime, the Goswami may also file objection bail in objection in the connected bail application.
Also, can I fix it? At this element.
Suppose you reject your bail, then victim is not necessary.
The victim is their informant, my lord. Husband, my lord. Informant has service complete. Service for the informant is complete. And girl has already been married. And as per my submission, my lord, as per ossification test, she was 18 years, my lord. And transfer certificate has been considered, my lord, which cannot be. There is a judgment of our High Court also, my lord.
What should be the basis? Yes.
Yes, I'm submitting, my lord. Sorry, my lord.
Where is the LCR? What should be the basis of age determination?
First is the first school's, the birth certificate, my lord. Then there should be first school certificate. If 1 and 2 is not available, 95, 1, 3, then the ossification test will be considered, my lord. As per ossification test, my lord, the age of the girl is 21 years, my lord. We'll also go to the evidence, my lord, of the PW1, my lord. That was not considered by the learned court below, my lord. He has mentioned all these things, my lord. He said, and they have produced, my lord, that the certificate from the transfer school, my lord. The person was transferred, earlier he was reading in a railway LP school, my lord. Subsequently, he was transferred, my lord. And from the transfer school certificate has been considered. And evidence categorically stated, we do not know, my lord. But it is the age of the girl at the time of admission of new school, my lord. Everything is available on record, my lord. Also, kindly go to the page 30 of the judgment, my lord. Age 30, my lord. X-ray for the age determination shows her age is more than 21 years. Page 30, my lord. PW1 deposed the as per classification test age of the victim was more than 21 years, my lord. Page 31, my lord. Third line, she do not have birth certificate. As because she denied, my honorable court has considered, Lionel court has considered. Read, my lord, immediately. One Subra. The evidence of PW1, my lord. Or OCP victim.
Why ossification test was done when there was a school certificate?
Because, my lord, the investigating officer, that is the, my lord, fault of investigation. There is a school certificate of transfer school, my lord. Transfer school, my lord. She transferred from, my lord, railway LP school, another school where certificate has been produced. Your lordship, kindly go through the evidence of that person's, my lord. Categorically stated, my lord. And this certificate cannot be considered. There is a judgment of our High Court, my lord. Fairly covered of that judgment. I can produce the judgment.
And give it.
Yes, ma'am.
Please, Your Lordship.
Yes.
The criminal appeal, my lord, there is an IA for bail, my lord. First of all, my lord, the petitioner was, the appellant was convicted for 10 years, my lord. And as on date, my lord, from the date of judgment, I am behind the bars for 4 years, 8 months, my lord. And the previously 3 months, my lord, almost 5 years, my lord. If your lordship, my lord, I will not trouble your lordship, my lord. My appeal, my lord, only 3 paragraphs I will show, my lord, if your lordship is satisfied. The appeal memo, my lord. Yes. Page 20, my lord, 20, my lord. Page 20. Last paragraph, my lord. PW1 doctor, lordship had found it, my lord.
This paragraph, yes.
Page 20, paragraph 19, last paragraph, my lord, below, my lord. May I read, my lord? PW1 doctor Anima Boro had examined the victim girl on so-and-so in connection with so-and-so, under section so-and-so, my lord. Next page, my lord. Deposed that on examination, she found the following. There is no recent sign of sexual intercourse, but the victim is accustomed to sexual intercourse. There is no sign detected. There is no injury on body. There is no foreign particulars on body or clothes. There is no X-ray report. So
How
her,
age was determined?
so her age could not be ascertained.
No, how then it was determined by
Birth certificate was there.
birth certificate?
This medical report, that is it, exhibit 1, my lord. Now your lordship will turn to page 23, my lord. Page 23. Page 23 also, my lord, the last paragraph, my lord, paragraph 31, my lord. May I read, my lord?
Yes.
The facts that had emerged in the mouth of the prosecution witness, particularly in the evidence of the victim girl and a medical officer, there is no denying the facts. There was sexual intercourse with the victim girl. Now it is to be seen who had access with the victim girl. In the absence of any evidence to show that any person, one other than the accused, had access with the girl, accusing finger in towards the accused as the victim girl, clearly stated, my lord, next page, my lord, clearly stated it was the accused who had committed the sexual intercourse, which are supported by medical evidence of PW1. My lord, now the question is, my lord,
What was her statement?
PW1, my lord, she indicated me, my lord. There is no doubt, my lord. Now, my lord, my submission is that, my lord, on the very that day, my lord, there was no sexual intercourse, but she was accustomed to sexual intercourse. But the court came to a finding, my lord, as the appellant had access with the girl, so he had committed sexual intercourse earlier, my lord. But can it be a ground, my lord?
No, that cannot be a ground.
That's only that point, my lord. That much, my lord.
What is her evidence PW1?
Evidence, my lord, that is PW3, my lord.
PW3.
PW3, my lord.
Who was these witnesses? The wife of the victim, wife of the um, accused was
Accused.
examined.
No, no, ma'am.
Then the other two persons were examined.
Yes, my lord.
What is their stand?
There no specific, my lord.
That hue and cry, all this they have
No,
said.
no, my lord. My lord, only contention is that, my lord, page 24, my lord, of my appeal, my lord. The court has came to a finding, my lord.
No, that's fine.
My lord.
Court may find. We may uphold this conviction if materials
Yes,
are there.
yes, my lord.
You are in a bail in a convicted case.
Yes, that's for.
Is not it?
Yes,
So we'll have to have a satisfaction that there is a scope of acquittal. This is one. Other is that there is no likelihood of hearing this matter at the earliest.
Yes, ma'am.
One main aspect is that whether we have a satisfaction that no, this is not this. This you have a likelihood of acquittal.
I think so, my lord. As because
That's
paragraph.
why I have asked, what about this two person? Because medical evidence in your favor.
Yes.
But the victim specifically said there was rape.
There was
And
rape.
there was resistance. So if there is resistance, why there is
On that particular day?
On
But the court came to a finding that she had a
forget about courts?
no, she had a sexual intercourse earlier, but
Oh.
she denied that, my lord. The earlier that I had sexual intercourse with the appellant earlier, my lord. She denied that fact, my lord.
No, that is fine.
My lord.
Question is this: she is a minor, admittedly.
Yes, my lord.
There is no dispute on that minor. Her consent will have no relevance. Second, third issue is that she has said you have raped her. And there are some eyewitnesses. Eyewitnesses are not examined, whether that is fatal or not. This is one aspect. Other part is that 2-3% after raising her hue and cry, she came. There is contradiction so far relating to medical, no injury remark, nothing. So
yes, ma'am.
according to her, there is a resistance. So if resistance, there ought to have something. So we can convict a person only on her sole testimonies if we think that she's trustworthy and of sterling quality.
That's
But here she says that some others are there. What are the statements of others? So then we may not believe her story.
my lord.
That is, I think that should be your argument.
Yes, that is my argument, my lord.
Where is the other two persons?
Yes, my lord. PW2 is the, my lord, mother, my lord. That's why I'm not. 3 is the victim, my lord.
Now what about this Nurjahan and Amirjan?
They were not examined, my lord. Nurjahan is examined, my lord. That is PW5, my lord.
PW5.
PW5, my lord. PW5, my lord. Nurjahan, my lord.
Get PW5. PW
5 is Nurjahan, my lord. the lordship may say. And dispute also, my lord, that I mean the judgment, my lord.
Why should we not believe her? Number one. Number two, that there was an hue and cry and people rushed to the place, and her testimony that your wife initially raised the hue and cry is corroborated by others. That there was a hue and cry, the accused visited the place,
Yes, my lord.
the residence. She was alone, parents were not there.
I also, my lord, for
Not that nothing has happened. Her statement also remain unshaken.
Lordship may see 7 also, my lord. Wife of the accused, my lord.
Wife of the accused?
Wife of the accused, my lord.
Where is that?
It was cross-examination was declined.
Is
7, my lord, record was.
7, no?
I know the informant as well as the accused, Ahed Ali. The informant filed the
I
form.
have almost exercised the final.
My lord. I am on bail, my lord.
No.
On the half sentence.
Half sentence that
yes,
can be a ground.
half sentence already undergone, my lord.
But we can complete the hearing right now. We have almost done it.
But otherwise, my lord, for hearing, I was not prepared, my lord. I would produce some case law also to that effect. So far, my lord, only A is concerned, my lord.
PW 7 or 8?
PW 7, my lord. 7, my lord, only 3 lines, my lord. The wife of the accused, my lord. Seven and 6, my lord. 6, my lord, she had the accusers, the.
You have completed the half.
Half.
What you say?
my lord, think that, my lord.
And one more
he
thing, my
is
lord,
not
one
a, my lord.
submission, my lord, for my learned friend starts, my lord. An appeal, my lord, I was filed, my lord, long back, my lord. The case of 2019. Every time they took time, my lord, for filing, my lord. This is the now
This one is
the
filed, my lord.
last occasion,
Filed.
my lord, they have filed, my lord. Bail objection. If your lordship goes to the bail objection, my lord, it is a mechanically filed, nothing, my lord. Nothing, no.
Now, what you say on these 5 years?
Yes,
No
my lord.
criminal hearing methods are taken.
Yes,
We
my
can fix it for hearing. No problem on it. But why should we give a preference to this case? Many people are in the queue.
Half of the punishment, my lord, my lord. So where my there is a conviction, accused is convicted, my lord. Half, my lord, when it is considered prisoner, my lord. Is my
Oh, no, on in appeal also, because that's why we grant bail. Because it's not likelihood of being heard. This is our fault. We are not being able to handle hearing matters.
the case, my lord, my
See, merit is also a doubt is no doubt created. And criminal case, what do you require? Only a doubt. A doubt is created. Why a doctor will say when she was examined immediately?
after 2 days.
2 days. That explanation also given by the, my lord, the judge, my lord, in the judgment, my lord.
Other way, my lord, doctor's evidence somewhat supports the, my lord, prosecution case because she is, my lord, accustomed to, my lord. It means, my lord, like, my lord, he has, my lord, some access to the victim, my lord.
No. That cannot be.
Access.
That cannot be in either way.
No, my lord, because, my lord,
A person having access to sex
yes,
is different thing, and she may have a, suppose she is a major, it in a case minor, but
this is minor. That
minor.
is what I am.
But you cannot presume that he is the person who is having continuous sex.
I am not on presumption, my lord. I am, my lord, going by the statement of the, my lord, victim, my lord, in the 160.
According to victim, she has been raped once.
Was by this person.
by this person.
He is
But
pointing.
the medical opinion is she is habituated to sex. There are two differences.
Yes,
One is a rape
yes,
for this, and she is habituated to
yes. That
or exposed to
there,
having this.
my lord, he
So
has,
therefore, you cannot have a presumption that this is a man. Then this presumption will go against you, that if this is the man, where is the explanation? Why have you not
yes, yes,
lodged complaint?
yes, yes. Regarding my lord, others, my
So
lord,
Judge could not have presumed. That cannot be. Judge could have said that this her, though medical evidence is against her, but her evidence is of sterling quality. So
yes,
I have no reason to doubt. So if no reason to doubt, that can be on a test,
yes.
one single
Judge's
testimony of the
totality,
victim.
my lord, all the evidences were, my lord, relied upon, my lord. 164, 161. Regarding the evidence of the other.
But court
witnesses.
has not come to conclusion that only on her evidence conviction is made.
Court is not on the, has not given any opinion that she was raped that particular day. Court is of the opinion that the accused had an assessed. Paying for bail, my lord, let the matter.
List it tomorrow. We'll pass the order tomorrow. By slip, I'll go through the.
That, my lord,
We'll
it
see.
will be hard after some time, some equal course, my lord. Because from the date of the FIR, I'm behind the bar. One item, my lord, item number 23, can it be taken up at 2, my lord?
Yes.
During the trial of a 498 case, lordship, before the learned court below, the husband filed a petition under section 311 for re-cross examination of the investigation officer. And that petition was allowed, lordship, kindly see page 26. Page 26, Annexure 5, lordship.
Yes.
Accused person is absent with steps by petition number so and so. His engaged counsel has showed cause of his absence, hard, perused, the prayer is allowed. Also, seen the petition number so and so filed under section 311 of CRPC by the engaged counsel for the accused person, praying for allowing him to re-cross examination of PW9.
Who is PW9?
Investigation officer of the case.
Why? Where is the application?
In space 24.
Huh?
Space 24. Next report, page 20.
Who is representing the other side? You are the wife.
Basically, though we have made party, the wife lordship actually.
Huh?
My 311 petition once allowed lordship. What happened, lordship? Thereafter, when we issued summon to the investigation officer, summon was not served. Thereafter, impugned order has been passed. Impugned order, page 30.
So by the impugned order is at
Page 30. Annexure 8.
you are not agreed by this order.
Yes, lordship. That petition was allowed, lordship.
Allowed.
In my favor.
Okay, now what happened? This is for further evidence.
Yes.
But not for your cross-examination.
Yes, lordship.
Now what
Evidence
is the
already
next?
closed, lordship, and fixed the case for argument, lordship.
Hard. Yes.
First it is allowed, after
Huh?
that, first allowed, after that.
First allowed.
That, my lord.
Allow that, okay, we'll have a cross examination. That is also without any reason. The lawyer comes and files an application, say that I forgot to do cross examine on certain points. Please, I'll call him for a cross examination. Court allows. Okay, is that so? Allow. No reason. Now PP says enough evidence is there. No further evidence is necessary. Okay, closed.
It is also allowed.
Officers should be sensitized. Learned counsel for the appeal. A Begum, huh? Learned. Any stay of the proceeding? No, let us wait for the service. In view of office note dated 6/4/2024, await service report in respect of respondent number 2. Full stop. By the present application filed under section 397/401 of Code of Criminal Procedure 1973, an order dated 11/1/2024 passed by the learned Judicial Magistrate First Class Dhubri in PRC case number 81/2019. Balanced. Full stop. The learned magistrate by an order dated 20/02/2023 20/02/2023 allowed an application filed by the accused / petitioner under section 311 CRPC to re-cross examine the PW9, that is the investigating officer. Yes.
Annexer 9, my lord. The petition has been filed, my lord. Or, my lord, calling the witnesses once more, my lord. That is now pending, my lord. That hearing.
Which one?
Lord, page 31, my lord.
31.
In the petition has been filed under 311. That hearing is pending, my lord.
We cannot even relegate it because he cannot pass this order, even in this application.
In my lord, it is
all are messed by the PP, by the counsel for the petitioner, and by the magistrate.
in 3, my lord, again it is kept for hearing, my lord.
That cannot, we will stay the further proceeding. I will, PW9. Though steps were taken or though summons were issued to the said PW9 when the matter was taken up on 11/1/2024, the learned additional public prosecutor verbally submitted before the court that sufficient numbers of PWs have already been examined, and as such, recording of further evidence may not be necessary in this case. On the basis of such submission, the prosecution evidence has been closed and matter was fixed for SD plus argument. Plus argument. Prima facie, such course of action shall not be permissible under law, inasmuch as the date was fixed for service for examination of cross examination of PW9 in terms of the court's earlier order dated 20/2/22. Telling the above, until further order, the further till the next date fixed, further proceeding in so and so shall remain suspended. Registry to list this matter accordingly with an updated service report.
It can be fixed, well.
Give a date.
Case is pending, my lord, charge sheet not submitted.
Not submitted, na?
And in
How many days?
59 days.
59 days. Period is 60 days,
Yes, ma'am, 60 days.
considering the length of detention. To the satisfaction of
SDGM, North Salmar of every.
DGM, not Salva. 20,000.
Appellate.
Yes.
Interlocutory application for consent. His Lordship, appellant in custody 7/2/2021, more than 3 years, Lordship. He was convicted under section 4 of POXO and also Lordship section 366. Lordship, have a look at the evidence of the alleged victim.
Have you taken fresh steps?
Lordship appeared.
Huh?
Respondent number 2.
Number 2, Lordship.
Statement of the victim, Lordship, PW.
Okay. Oh, okay.
Yes.
Lordship, after 8 months of the incident, Azahar lost. While she returned back from the house of the accused person, and then Azahar lost, there is a marriage. Although she denied the fact that she has no consent, the Lordship.
When the incident happened?
It was happened on 21/11/2016. Azahar lost in the year.
Just a minute. When she, according to her, she fled away from her.
Lordship, it is 21/11/2016.
And when the affair was lost?
Lost in the year 2007, in the month of August 2017.
So you want to say after return?
Lordship.
Return in November 2016.
2017, Azahar lost.
And return from your custody when?
Lordship, according to her version, it is June, July, and thereafter 1 month of return to her home, she lost the Azahar.
Why should you grant you bail?
Lordship, whether our statement made out any case of kidnapping, Lordship kindly have appreciate this fact. And other Lordship.
Absolutely.
Lordship, other aspects.
As a minor, she is her statement is constant that you have forcefully taken away.
Lordship,
and confine her in your residence.
Lordship,
Her mother, father stays somewhere else. Mother expired long back. She was 13 years age. Why should you grant you bail?
Lordship, is it a believable story? She stayed there for.
You think
she admitted. She admitted 3-4 months she resided in the house of the accused. But
she was tortured.
Is it a case of POXO or it is a case of Lordship child marriage, Lordship? Yeah. My submission, Lordship.
Child marriage is forceful. It will come POXO. How her age is determined, Suhas?
It is by the doctor. No other document proof. The Lordship PW3. Have a look at evidence of PW3. Page 6. Lordship page 8.
What is the conviction period?
10 years, Lordship. Under section 4 of POXO and 366, 7 years.
PW3.
Lordship.
Doctor.
Doctor. Page 8.
Yes.
8. Age of the individual is above 14 and below 16 years.
When she was examined?
He was examined, Lordship, before the trial court. Sorry, Lordship, by the doctor, it is on Lordship 77, 2017. Lordship, more than 3 years, that part may be considered.
List this matter after 2 weeks. Not a case of bail.
Of life.
Yes.
Challenge is a revisional order, my lord. It's a 145 proceedings, where the executive magistrate declared possession to be in my favor. My lord set aside the judgment, but did not render any finding. Now, if your lordship peruses the order sheet, my lord, in 2018, there is an order that R to respondent number 3 had passed away, and I was directed to substitute, my lord. And I could
Who is
not-
in possession, agent? Yeah.
He says he is in possession.
How can you be in possession? And how can these courts can interfere, enter into all these issues after a determination in a second appeal? Huh?
They desire, my lord, they can file a suit, no difficulty in that, my lord. Possession has been declared in my favor by the executive magistrate.
By the session court, your lordship, it is reversed. And moreover, your lordships,
No, tell us, forget about this sessions court. What about the second appeal? What about the suit, the second appeal?
suit is completely different, your lordship. It is not connected with this case. He has a sub connection, contest of some suit, your lordship, completely different case.
Now, what to be done today?
Here in this case, one thing may be considered, your lordships. Respondent number 3 expired on 23/4/28, your lordships. Had order dated 27/11/18, your
That
lordships.
is what
He
I was
was asked
submitting, my
to
lord. My lord, I could not
substitute,
get
your
the names
lordship.
of the
But
legal
he has
errors. My
not-
learned friend is
till date,
appearing.
he has
Who-
not
Who
substituted.
represented respondent number 3?
Him, my lord.
Give the name.
Give the names, my lord. Let him give
Your
submit.
lordships,
Give the name. Don't be technical.
I will give the.
You are not
But
before
your
a civil
lordship-
court.
Your lordship.
You are not before a civil court. Give the names, or we are admitting it and staying for final hearing whenever it comes.
I'll give the name, your lordship.
Give the name.
But one thing may be considered here in your lordships. It is out of 2018, your lordship. What is waiting? He is waiting for so many.
According
It is
to
already
us-
awaited, your lordship.
According to us, it is a glaring illegality by the learned sessions.
It's,
So if you want to go further, we can proceed further.
I'll
May-
give the date, your lordship, the legal years names.
The order dated
27/11, my lord, 2018.
the respondent number 3 expired long back. However, is submitted by Mr. Deka, learned counsel for the petitioner, that appropriate application for substitution of legal years of respondent number 3 not be filed for want of details of the legal years of respondent number 3. The Cha learned counsel representing the respondent number 3 submits that he will furnish the details particular of the legal years of respondent number 3 to Mr. N. Deka, learned counsel for the petitioner.
Possibly, as far as possible, because he already expired. I'll try. So
Don't be
after date,
technical.
after date, your lordship.
I'm again repeating, you are not before a civil court.
Your lordship.
You are not before a civil court. Here these tricks,
Your lordships.
we know. Within a period of 2 weeks from today. On such details of the legal years of respondent number 3 being furnished, comma, the learned counsel for the petitioner. The petitioner shall thereafter file the necessary application for substitution of the legal years of the respondent number 3. Is after 3 weeks.
All right.
19. Please, Your Worship.
Yes.
For the respondent number 2, here the petitioner filed this revision petition for quashing the interim maintenance. It is not maintainable. my lord.
Any interim order?
Interim or no, my lord.
None appears for the petitioner on call.
Last occasion also they have not. appeared.
None did represent the petitioner when the matter was called on 28/3/2024. The present petition, revision petition filed against an interim order of maintenance must, where is that?
It's 21.
Passed by the learned Principal Judge Family Court Borpeta in FC criminal case number 109 of 2023 in exercise of its power under section 125 CRPC. By the aforesaid order, an interim maintenance of rupees 2,000 was awarded in favor of the petitioner, in favor of the respondent.
Number 2.
Respondent number 2. Full stop. And notice was issued to the petitioner herein. Such order, in the considered opinion of this court, is an interlocutory order. That being the position, the petitioner shall have all opportunities, fair opportunities to present his case before the learned magistrate below. And no case of any jurisdictional error has been made out. Accordingly, this court is of the opinion that no illegality has been committed while passing the interim order dated 21/2/2023. Accordingly, the revision petition stands dismissed. However, the observation made in this order may not be treated as any comment on the merit of the claim of either of the parties. First,
Interim order is there, let it be.
interim order pass earlier shall continue.
Obligement.
This criminal revision petition is filed for the Zimma of the vehicle lordship.
Lordship, the IO has take some time, Lordship.
A person is running his family with the e-rickshaw.
Lordship.
In a similar case, Zimma was given lordship, that is annexure 6, we have annexed. Page 21.
What is the order here? Impugn
That
order.
is page 18. Copy of the order dated 29/11. My apologies, Lordship. Annexure 4, order dated 23.
20?
23, page number 17.
17. Swenso. assailing the legal, assailing an order dated 23/8/2023 passed by Special Judge, what Special Judge? Court of Special Judge, Bongaigaon.
So Special Judge Bongaigaon.
Special Judge NDPS or what?
Not written as NDPS or
But it should be. Judge NDPS Bongaigaon. In connection with, where is your application? Application for Jimma.
Lordship.
Now, how do you know the number of the application? That order has been passed in such and such.
We have stated Manikpur PS case number 10823. And
Application. It is application.
Will pass order where? Where is the petition? What is the number? What is your statement regarding Jimma?
Rejected petition we have not annexed, Lordship, but the order we have annexed, that is page 17 annexion.
Order also does not reflect the application.
In annexure 5, Lordship, there is petition number mentioned, Lordship.
What is the number of the Jimma petition?
The
This is
number,
not the way a case is filed. On the prayer of the learned counsel for the petitioner, matter stands adjourned after a week. Permitted to file an additional affidavit to bring on record the application file for Jimma.
obliged, Lord. The date may be fixed, Lordship.
You file, make a mention.
Used appealant, my lord. Suspended order date. Judge Borbeta, my lord.
Judgment in order dated 19
Under section
passed by
against
the learned session judge. In session case na silo ha. Admit,
two
call for the
sentences.
record.
Undergo rigorous imprisonment for 7 years, my lord. So I
Okay. Admit.
Okay. The criminal revision lordship, the impugned order case spoken lordship.
Lordship, a report was called for Lordship. We have received the report and it is reflected that Lordship already attached under section 11 of the ACP Act 2021, and if the vehicle left for Jimma, then the offender again use it for the same kind of offense because it is an organized crime and which will hamper the society that much.
Can that be a ground?
It is given by I.
Where is your Jimma petition?
Order itself reflect.
Huh? Why are you not annexing the Jimma petition? Where is the order?
Case 14 lordship.
What is section 11? Section 11 of. This is the same reason. That's why you'll have to see. You are without the book and you are here to argue a Jimma petition. On the prayer of the learned counsel for a petitioner, matter stands adjourned and be listed after 2 weeks.
Assam cattle prison.
Yeah, we know that.
No.
But if a person comes.
Lordship.
Yes, Mr. Dutta.
Lordship, in here, Lordship, we have received the report, Lordship. Lordship, it is said the ownership can be ascertained by producing of the cattle selling receipt by the petitioner. The cattle can be given Jimma to the absolute owner if they produce documents before competent authority which reveals the ownership of the same. And your honor deem fit. It is 22/4/2024.
Here, my lord, the petitioner was granted interim bail. And accordingly, we appeared before the IO on 23/03/24. Where my lord, I can file an affidavit in the record and have produced all the documents in original.
Now, where are those documents?
The police station, what kind of report is that, my lord?
File an affidavit.
A serious thing, my lord.
You file an affidavit.
Yes, my lord.
Heard Mr. N.J. Datta, learned counsel for the petition. The present application is filed assailing an order dated.
Order dated 18/03/24. Sorry, my lord, 27.
Are these police stations are having CCTVs under Supreme Court's direction?
That I don't know.
This is why the Supreme Court is time and again saying.
What about officer? And Annex 3, my lord, page 14 is the impugned order.
Where?
My
Page?
lord, page 14, my lord, the impugned order.
Order dated 27/3/2000, assailing an order dated 27/3/2024, whereby the learned SDGM in bracket S-2 Kamrup Metro refused to grant Jimma of 20 numbers of cattle placed in connection with Bokista PS case number 131/2024. This court called for a report from the bidding authority. A report has been submitted. The effect that the petitioner has not been able to produce any documents regarding ownership of the loaded cattle, no ownership of the cattle, and therefore it is further reported that if ownership can be if proof of ownership can be produced, the Jimma of the cattle can be granted to the petitioner. Responding to such report, Mr. N.J. Datta, learned counsel for the petitioner, submits that the petitioner was granted an interim anticipatory bail by this court under its order dated 18/3/2024 in AB 723/2024, and accordingly the petitioner appeared before the IO
23/03/24
on 23/03/2024 and submitted all the original receipt showing the purchase of the kettles, and therefore such stand of the IO is not correct. In view of such controversy, let the petitioner file an affidavit when and in what manner such original receipts were handed over to the IO.
In the case diary, entry is still 5/3/2024.
That's why.
Thereafter, no entry is there. So,
but this
if
report
we
is of
appear-
22/4.
Yes, I understand, Milord. But
You get it updated.
updated case diary has to be, Milord, brought.
Uh,
We may be permitted to return the case diary.
in
for
the
updated-
meantime,
updation.
but we are concerned about the cattle.
That's a serious thing, Milord.
But
That amounts to misleading the court, Milord. I understand.
250 rupees per day we have to give. 2050, my lord. Well, it comes to 7,200 and it is almost 45 days, my lord. Now, will they bear the cost, my lord? 7,200, 250?
I think maybe noted, Milord. Milord, I have produced the case diary. And Milord, the entry shows
Mr. Das, learned additional public prosecutor, submits that the case diary is up to
5/3/2024.
5/3/2024, and therefore he may also be permitted to turn back the case diaries and to get it updated. Full stop. Prayer is allowed. List this matter on
প্রথম থানা এইটো
বশিষ্ঠ
বশিষ্ঠ কেতিয়া ফাইল কৰিবা এফিডেভিট
7,250 per day, my lord.
little bit harsh, it's 30.
30. Sir, Das,
I think will be matter.
you advise your client properly.
Yes, yes, my lord. This is a serious thing, my lord.
Can it be 26, my lord? Because every day, otherwise case will go.
Okay, let us have a try.
You can fix the date, but today is gone. Tomorrow, my lord, they may come.
Today is
22nd.
26th will be what day? Friday. Let it on Monday.
You'll go,
Let it be on Monday.
Monday means 29th.
29th. 20.
I'm obliged.
The report is kept on record.
Fabulous, Lordship. Lordship, as per Lordship direction, my lord, we both the parties have filed our assets and liabilities as per Rajnesh versus Neha. Yes, ma'am.
Okay, where is that?
Sorry to interrupt, madam. In that order, my lord, that report we have submitted, that may be kept in record.
Kept on record.
My, obliged. I'm sorry.
Our affidavit, my lord.
This is what is this? This is 125 or what?
Lordship, 125, ma'am.
Where is the order?
I'm assailing order, my lord.
No,
Page
no.
47.
That order to file affidavit. So you have paid the half amount.
Lordship.
Huh? Where is the impute? There is no order to file affidavit. Huh?
Order dated 6/2/2024, my lord.
6/2.
Lordship.
Both parties were directed to file assets and
Where is the impugn order?
Lordship, page 70,
Page
47, Lordship.
43.
47, my lord. A revision has been preferred, my lord, before the learned session was, my lord. Exam is this. Quantum, my lord, quantum of maintenance, my lord, was 6,500. It is not bearable to the petitioner, my lord. He is the worker of a bakery, my lord. Has also family, my lord.
What is your affidavit?
Like B, my lord. Yes,
from
This
page
payment is directed again for the minor. Isn't it?
legitimate child. And I have also annexed our bank statement, my lord, for 3 years.
Not a case for interference.
So this is a
1,500.
second revision, my lord.
Huh?
This is the second revision. First revision, my lord, was preferred before the learned session judge, my lord. Session judge dismissed it, my lord. Against the order of learned judicial magistrate, my lord. First class, my lord. Order of judicial magistrate is start from page 37, my lord.
Why should he interfere in this?
1,500 not
That
bearable
cannot be a
to-
ground.
That is my lord.
That cannot be a ground. There is a factual
And the
determination.
income is of the petitioner is only 12,000, my lord. If he paid 6,500 to the, and he has also wife, children, and other parents also, my lord. They have not considered the assets and liability, my lord.
You are not interfering in this. There is no stay order.
No, my lord. No, it's
He's making the payment.
no, my lord.
Last, what about the last direction? 50,000 by
50,000 already paid, my
50,000,
lord.
my lord.
40,000.
What about the other?
Other amount not paid.
How much are you paying?
1
1
lakh,
lakh-
1,05,000 is being paid, my lord.
Out of 270.
Out of my lord, 288.
288, 1 lakh
5,000.
5,000. Now, what is the current payment made?
No
Currently
payment is being made.
monthly payment? We'll dismiss this.
Amount is so excess, my lord.
Tell us, can we make a determination in exercise of our revisional jurisdiction after concurrent finding of two courts? First of all, whether it's a maintainable.
Lordship, in the case of Rajnesh versus Neha, my lord, it is
Ah.
pending procedure. If there is pending, the matter may be remanded back to the learned trial court, my lord,
Why?
for redetermination, my lord.
For what
qua-
reason?
Quantum of maintenance, my lord.
Why? For asking that you remand it back. You must have some reason.
Quantum of maintenance, my lord, that is.
Quantum cannot be determined in a revision, that too in a second revision. Concurrent
In this case, my lord, one judgment of our court, my lord, Ratan Datta, my lord.
where is that this applicable here? According to you, she is not your wife. Maintenance has been directed for a child which you have fathered. Why? Where is there is not a dispute between husband and wife?
But in the
Who will disclose whose income? Where is the responsibility of the mother? Tell us.
maintenance petition has been filed by the
For a minor, for the minor,
Lordship.
not for her. For the minor, marriage dinner took take place. This is facts are different. It is an extraordinary case. Sir, Islam, we'll pass this order next week. This week, Friday.
I am relying on a decision, my lord. Sorry to my lord, I have not given the list my lord, in the morning, my lord.
Give the
1999 6 SCC, page 3 to 6, my lord.
What
And
is
the
what?
power and scope of 482, my lord, has been discussed.
That is. On that line only, I had a judgment, that's why. We have some technical problem today to pass a long judgment. So that's why we are fixing it on Wednesday. List this matter as agreed to by the learned counsel for the parties. List this matter day after tomorrow. 24th.
Homeless.
Yes, what is this?
This is a petition challenging the order passed in a 145 proceedings. Order is at page 11. Lordship, before going to the merits, Lordship, it was passed to, I had engaged an advocate. It was passed in his absence. May I read, Lordship? Lordship, second paragraph is, I am reading. During proceedings, both parties were called upon to submit their land documents for the respective claims as to the fact of actual possession of the said disputed plot of land. In this regard, first party submitted all the relevant land documents, but the second party could not produce any relevant land documents into the matter. After verifying and perusing of the first party allegation petition and police spot verification.
This is the final order.
Yes, final order.
Yes.
My lord, I'll just make certain submissions, my lord.
Forget about other submission. First tell us, can a determination of possession under 145 be made the way this order has been passed?
My lord,
Yes or no?
My lord,
Yes or no?
My lord, because my lord, the executive magistrate has, because why I'm saying so?
Yes or no?
Because my lord, he, after getting the notice, he came by a criminal petition before this honorable court. He did not participate. Kindly see the orders.
No, I'm not saying forget about him.
Yes, madam.
Forget about him.
Yes, madam.
A determination is to be made, then so and so in under possession. Where is the discussion that these are the documents? That these, on the basis of this, these are the evidences. Where are those?
My lord, the LCR is there, my lord. My lord,
So are you expecting this court to decide? Is this an order?
My lord, that's correct, my lord. But
If
my
that's
lord,
correct, we are setting aside and remanding this matter. As simple as that.
my lord, only for a moment, my additional affidavit will be seen. My lord, only for a moment. I'll just.
You are a seasoned counsel.
Correct, my lord.
This is an
I'm
application.
only showing the negligence on his part, my lord. The moment he received the notice from the learned magistrate, my lord, he approached the honorable court, my lord.
Forget about him for the time being. Suppose he has not appeared. He has not participated. Can an order be passed in the manner that has been passed?
My lord, I appreciate that part, my lord.
If
My
that
lord
is correct,
my
it
lord.
will
That
go.
part, I have nothing to say. But my lord, kindly see the negligence. Immediately.
So you want to say that in exercise of revisional power, because of somebody's negligence, we will have to condone the action an exercise of power, illegal exercise of power of a officer.
I'll leave it to your lordship, my lord. My lord is 100% correct.
If I am 100% correct, let us not waste the time.
But my lord, why I'm opposing to this person? My lord, these are land mafias. Why I am saying so? From the
So
criminal
you want
petition.
to decide me to who?
No, my lord, I'm not. My lord,
Then where you are going?
they are saying that they are in the land, they are in possession. My lord,
These
possession
are
handed over
facts.
to me, my lord.
These are facts.
My lord, possession handed. They don't even know the dark number. They don't have annexed a single document. That
Very good. Very good.
My lord, to remind, my lord. My lord, I'm agreeable to that. I'm
Just
agreeable
read the
to.
order.
I'm agreeable to that, man. I'm agreeable to that.
This cannot be an order.
My lord.
But you will not get the order today, huh? Heard Mr. Bora, learned counsel for the. This is not the way. Everything should be a.
Only, my lord, only submission, a time frame may be fixed, my lord. Within that time, my lord, the learned executive magistrate will dispose of after hearing both the parties, my lord. A time frame may be fixed, my lord. This much, my prayer.
In a 145 proceeding, first there has to be a preliminary order, whether a dispute arises or not. There
It's the first order, what?
is a final order.
Final order on first date.
No.
Any date for-
No. There has been continuous dates, my lord. That is why, my lord, I was.
Witnesses were examined.
Yes, my lord. 4 witnesses were examined, my lord. That is why, my lord, I was just trying to show your lordship from page 32, annexure 1 in the additional affidavit, the orders, my lord. He came to the High Court, my lord. He was knowing that the matter is pending before the learned executive magistrate. He refrained from appearing there, my lord.
The earlier petition was for a, because I
No,
was
my lord.
not given the certified
No, my lord.
copies. The lordship, the record is here.
Yes, the other record is here, my
Petition
lord.
is 1003. Because
This
I
is
was
after,
not
my lord.
given the criminal
On the
certified
7th
copies.
date, my lord, the final order was passed. On the 7th date, my lord.
Let's hear to this. Where is the examination of witness?
My lord, 2610, my lord. 2610 order, my lord. 2610, 2022, my lord.
Where are your statements?
My lord, I am only from the orders, my lord. The orders which have annexed, my lord.
Where are their
Rest I haven't
statements?
seen the, my lord.
Where are their statements? There is no statement.
But in the order sheet of 2610, my lord.
26 and it is so-and-so Islam, is so-and-so. Their statements are recorded.
Recorded.
Next date for order.
Next date for order. Because he was continuously absent. Initially, he.
Forget about him. I'm
executive
telling,
police
I'm repeatedly telling you.
That correct, my lord.
Forget
I'm not
about
on that.
him. Let me see the examination of the witnesses. Statement of the witnesses recorded. Nothing is there except the documents. Not even case of remand. Do you know the application? Have you ever gone through the application? 145? Huh?
Initially, my lord, a police verification report is there.
No,
that
no,
report
for
is there.
police verification later on. What was the application? Filed before the subdivisional officer civil Bokajan.
My lord, that, my lord, I have not annexed because it was not annexed in the criminal petition also, my lord. So I did not had that, my lord.
It is there in the record 29(3).
Let me read it for you. I am the rightful, this is your application. I am the rightful and beneficial owner and patta holder of land situated at Lahorijan, Karbi Anglong, Assam. By a tenancy agreement dated so I rented out a room standing in above said land at Lahorijan along with parking area in my patta land so for a period of 3 years to Mr. Torun Kumar Nandi. You are Torun Kumar Nandi, now residing at Bokajan. Upon expiry of the said tenancy agreement, I gave grace period and approached my tenant to vacate the room and the parking area since I am in need of the room and area of my personal use as my sons have grown up and want to use my room and space for their employment purposes. But surprisingly, instead of vacating the room and the parking space, he has stopped giving me rent since last 6 months, nor vacant my land, and where is he is running parking illegal without license.
Only seen the orders and whatever was there.
145.
He has admitted I am in possession.
But my lord, if the criminal petition is seen, what my learned brother has written, they are having adverse position, my lord. That is what the ground he has taken in the criminal petition. Kindly see, my lord. Kindly see in the criminal petition, my lord. Kindly see. He is not admitting that he is a tenant. Kindly see. My lord, page 7J. Page 7J. Well, 145 is only with reference to position, my lord. If I am evicted from the position, my lord, then my lord, for recovery of the position, to place me back in the position, my lord, 145 is there, my lord.
Why don't you file a civil suit?
My lord, since my lord, they came up, that proceeding was there, my lord, they came up with a criminal
This is a
petition, my lord,
civil
and
suit.
they
You
Correct,
admittedly
correct.
say tenancy, go for eviction. You have all this ground, bona fide requirement.
Yes, everything is there, my lord, everything is there.
Everything is there. You go
Everything
there.
is there.
Hard. So and so. The present application is filed and assailing an order dated. Follow. Order dated 3/11/2022.
Yes.
3/11/2022. Whereby the possession over that is so passed by subdivisional magistrate Bokajan, isn't it? Subdivisional magistrate Bokajan in exercise of his power under section 145 CRPC and declared
But it would be additional district judge, Kazan subdivisional.
additional
My lord, he is holding both the posts, my lord. As per the post title, my lord, of the magistrate order, he is holding both the posts. He is also holding the post of additional district magistrate and subdivisional magistrate.
as a subdivisional magistrate, he has exercised this power.
My lord is correct.
Subdivisional magistrate, not judicial, subdivisional magistrate Bokajan. Whereby possession was declared in favor, possession over the disputed land was declared in favor of the respondent hearing. Respondent hearing. The record was called for by this court and them is received. Perusal of the aforesaid order reflects that an application was filed by the petitioner respondent hearing before the subdivisional officer within bracket civil Bokajan by the respondent column, filed by respondent so and so, which is quoted herein below. Page 5 of the record. On the basis of the said application, on 29/3/2022, the learned SDO, or in short SDO, learned SDO forwarded the same to the officer in charge Khotkoti police station to inquire and submit a report. Thereafter, on the basis of the report submitted by an order dated 20/06/2022, the learned as SDO drawn a proceeding under section 107/145 CRPC and issued notice to both the parties. Subsequently, the record further reveals that on 26/10/2022, five witnesses on behalf of the
First party.
was recorded. And next date was fixed on 3/11/2022 for order. It is important to note here that the present petitioner, who is the second party in the aforesaid proceeding, though appeared in the proceeding initially, however, he remained absent on 15/10/2022 and 26/10/2022. Thereafter, on 3/11/2022, the impugn order was passed. After perusal of the record, yes, statements are there. You are Mr. Sethi.
Yes, madam. Subhinder Singh Sethi, madam.
Thereafter, the impugn order was passed. Holding position. Full stop. The impugn order reflects no discussion as regards the evidence laid the proceeding and how the learned officer has made its conclusion on the basis of such evidence. Thus, it can be said that though a conclusion is made that the first party / respondent herein is in possession. However, such conclusion is based on no material. Be that as it may, the most important aspect of the matter is that a bare perusal of the petition filed by the respondent number 2, shall disclose that the dispute is as regards a landlord and a tenant and non-payment of rent and non-vacation of the tenanted premises after expiry of the tenancy. Therefore, such dispute in the considered opinion of this court cannot be turned
My lord, only one part, my lord, only one, my lord. Since the schedule, my lord, connected, my other connected land is also there. Now this case is only with reference to a room and 2,000 square feet.
Room.
Yes, room and 2,000 square feet, my lord, that part may be noted down.
No,
Otherwise,
we have noted. That we
otherwise
have-
he'll capture the other part also, my lord, because I'm
No,
doing my.
we'll say that. We'll say that. First up, it is of a dispute is of a landlord and tenant. Kiba kolo na? Ki kolo? Landlord and tenant, and cannot be termed as a dispute covering the provisions under section 145 CRPC. That being the position, the parties should be relegated to the civil court for determination of their disputes. Accordingly, the impugn order as well as the proceeding under so and so are quashed with a liberty to the parties to approach the appropriate civil court. So far, the same relates to
one small room and 2,000 square feet parking area, madam.
Relates to the tenanted premises.
As per
That
the
is,
schedule in the order dated
the
311.
premises that is a land measuring 2,000 square feet covered by periodic patta number 134, dag number 06/4, situated at Lahorizan non-K village, Mauza, Borjan, under Borjan 1, number 1 Borjan, under Diffu Revenue Circle, surrounded by north, south, east, west. See page 3, pencil mark. Page 3 of the order, comma. Do we need a status quo in regards of the scheduled property?
Because I require a status quo because I'm already in position, my lord. I'm already in position.
Therefore,
Because I was handed over, because he needs to file.
Position, and on the first date, I requested a status quo. He objected to the status quo. Therefore,
My lord, what I'm on is
Therefore-
my lord, what I'm on is that if sometimes, my lord,
Lordship,
my position is
status
gone,
quo may
if
prevail.
I am entitled to, I seek an recovery of my position, my lord. This is what the Supreme Court says, my lord.
No, you can seek a recovery, fine.
He will seek because I am being handed over the position, my lord.
That's why we are saying a status
Quo, my lord.
Status quo,
Yes,
full
my lord,
stop.
deeply obliged.
Till
refers
the
to scheduled premises.
parties approaches the appropriate forum, status quo as regards the possession of the property as on date shall be maintained.
Deeply obliged,
Deeply
your lordship. Deeply obliged, your lordship.
You will get this order, may not be to tomorrow or day after.
Deeply obliged.
That shortage of hands.
Deeply obliged.
Taken after some time.
I think this will be almost last meter. What is this?
The impugn order is at page 23, 24.
What is under challenge? Impugn under page?
Page 23, my lord, 23 and 24. Page 24.
The prayer of the learned counsel for the petitioner. After a week. What about the report?
That report, my LCR received, my lord, in this case. The report is of.
Okay, she is seeking a time, we'll see.
Yes.
Whereas we are having some. Yes.
Also regarding the maintenance, my lord, next week, my lord. That regarding, my lord, assets and liabilities, my lord. And they have just now filed one objection, my lord.
The prayer of the learned counsel for the petitioner is this matter.
29, my lord.
29. Yes.
This matter concerns to the present accused petitioner who was aggrieved by the order by which the respondent number 2 was allowed to be recalled as a witness, my lord. That is with regard.
Where is that?
Yes, I'm for the respondent number 2, my lord. The respondent has taken brief from. He's not.
Now what to do? You have taken a brief, don't appear. That's all. Yes. Yes. This is in by order. I think you have made a mention. Yes, are you proceeding or what?
Lordship, if that be the case, my lord, then because I was told that they would be withdrawing, probably they are not keen to depose as witness in the sessions case as well. That was what I was told, my lord. So if that be the case, my lord, then we might also withdraw, provided they are not keen on pressing. But right now it seems that, my lord, my learned friend is
They are
not appearing.
withdrawing.
But of course, then the cause of action, my lord, the petition is, my lord. Then under such circumstances, my lord, can this be fixed on 25th, my lord, for hearing?
25th.
25th for hearing, my lord. Deeply obliged, my lord.
Not for hearing, admission. Has agreed to list this, no, it is submitted that the submitted by the learned counsel for the respondent number 2, that the brief has been withdrawn from them. Yet as it may, it is up to the petitioner to engage or not to engage a counsel, as much as notice has duly already been served upon the respondent number 2. Respondent number. But the learned counsel submits that matter may be fixed on 25th for consideration. Prayer is allowed. List this matter on 25th.
Deeply obliged.
Has left the court due to
On which matter?
55 regarding.
It's after a week.